Good morning, Mrs.
Good morning.
Would you mind just giving me a moment to make sure my computer's...
Of course, sir.
Thank you.
Thank you. Can I start with two things, really, that arise from yesterday? Firstly, just to sort of respond a little more on Carter and Russia. Having sort of reviewed it again and apologising again, because in one sense I'd forgotten it. It wasn't that it was unfamiliar, but I had forgotten it in the context of the question. In our submission, in one sense, it's of limited its significance to the issues I raised about the submission I made about the key test being the key test essentially being whether or not steps had been taken to ensure that the next of kin were able to safeguard their interests. Because, of course, in that case, the question was whether the victim in that case was able to rely on the findings of the public inquiry. The question was the admission of the evidence into the proceedings in the European Court. One sees that at paragraph 110. And that meant there was no... I mean, in simple terms, the victim was happy with the findings. They weren't complaining about whether or not they were able to safeguard their legitimate interests. So nothing in that case undermines the real point I was trying to make yesterday, which is that the test, we say, applies by reason of Article 2, is whether the next of kin were involved to a sufficient extent to safeguard their interests. I'll come back to that in a moment, because the second thing I want to address in a moment is the questions that were asked about whether or not effectively the special advocate adds anything to counsel to the inquiry. The second thing I would point out, my memory of yesterday is that you raised, sir, the issue of Carter in circumstances where I had raised the Article 6 case law, recognising that Article 6 wasn't directly in issue. It may be of some relevance that the European Court in Carter, in fact, cited YAM. You see that at paragraph 108, which is an Article 6 case, and so certainly regarded it as of some relevance, the Article 6 case law. And of course, the point I drew from the Article 6 case law, which is sort of why, in one sense, we've taken the position we have, which is not to challenge, in one sense, the principle of a closed hearing, but to argue a special advocate is needed as a mitigating factor. The point I was making about the Article 6 case law was that the European Court has recognised that the state may need to withhold things from a procedure at times, but at the same time has indicated that it's important that there are mitigating steps taken to balance the issue or the unfairness that arises from that. And really, in one sense, to pick up from what I've just said about Carter and Russia, it remains our submission, and just to summarise where we are, because I want to come back to the second issue in a moment, which is the advantages of a special advocate over counsel to the inquiry. Our submission is, in summary, when looking at case law, the legislation I took you to yesterday, is that Article 2, what the factors you need to consider, or the test you need to apply, sir, in our submission, is if Article 2 is engaged, whether without special advocates, essentially, there is sufficient involvement by the family to ensure that they can safeguard their interests, whether putting it in an alternative way, but to the same effect, whether the special advocates are needed to safeguard the interests, the legitimate interests of the family. If at the domestic law test we would submit may depend on an interpretation of Section 19. We made the point effectively that restrictions have to be minimised in terms of Section 19. To the extent that submission is accepted, our position would be that denial of a special advocate, because it is an enhancement of rights, would need to be justified in Section 19 terms. If that's not correct, in any event, what we submit is that the key issue, based on the cases I've highlighted, is fairness, and is an appointment needed, essentially, to ensure fairness. That's then where I come to the second issue I wanted to sort of return to from yesterday.
Are you moving on from the Article 6 discussion?
Yes, yes.
There's something I just wondered about, and I'd be grateful for your assistance with. I understand the point you make about Article 6 and the various case law where the court has made it plain that in derogating or in providing circumstances which are less than adequate, some kind of compensatory mechanism can be put in place. Now, that's all been discussed in the context of Article 6, but I wonder if there's not some discussion of it in the context of Article 2 as well in the European case law. And I'm thinking about a number of cases, but perhaps two in particular, where the court has observed that Article 2 doesn't automatically require next of kin to have access to police files or copies of all of the documents during the course of an ongoing inquiry, or to be consulted or informed of every step. Now, that has been said on many occasions, and perhaps very recently this year in Vyklashova, perhaps, against Ukraine. I'm not sure of the pronunciation.
Yes.
But it was also articulated in the case which you presented, Armani da Silva, where the court reiterated its approach to the procedural requirements involved in a case where Article 2 was engaged. And it commented that disclosure or publication of police reports and investigative materials may involve sensitive issues with possible prejudicial effects on private individuals or other investigations, and therefore cannot be regarded as an automatic requirement under Article 2. And it said the requisite access of the public or the victim's relatives may therefore be provided for in other stages of the procedure.
So that's, in one sense, goes back to the submission, and it's links back to the submission, and it's why I took you through, in one sense, the detail of Amin. Because if you remember in Amin, when you looked at the various stages, when Lord Bingham looked at the various stages, he started with the police investigation. In the context of the police investigation, he said absolutely no criticism of the fact there was no public or family involvement in that, for understandable reasons, because police investigations, as we all know, need to be conducted in private. He then went on to look at the processes which are perhaps more analogous to the sort of process we're talking about, because it's expected to be in public. And he looked at, if you remember, the Burt investigation, which was more of a sort of, I think it was Burt, I can't remember the name of the individual, I may have got that wrong, but it was more of a lessons learnt, lessons for improvement type exercise. He looked at the CRE process, which was similarly, And he was critical, not critical, but he was saying they were inadequate for Article 2 purposes because they didn't involve the family and didn't involve adequate public concern. So the question is, and this is, it comes back to, in one sense, what is it that's distinct? And this is why I was trying to draw, I went back to the test and went back to Amin. What is it that means the families don't have any right, for example, to participate in the police investigation, but do have a right to participate in the processes like the CRE? The reason we would submit is the only way in which that can be assessed, because it's the only test certainly we've been able to identify, is the legitimate interest test. Why is there a legitimate interest in the CRE process in a way that there wasn't in the police investigation in Amin? The reason we submit that is that in the Amin process, in the police process rather, what is the purpose of the police process? It is to bring a prosecution if there's sufficient evidence. That would be potentially undermined by family involvement. In the lessons learned process, which is more analogous to this, there is a legitimate family interest because going back to the purposes of the Article 2 investigation set out by Lord Bingham in Amin, the families have an interest in ensuring that lessons are properly learnt so that they can have that reassurance going forward that things won't repeat themselves. And so that's the distinction we draw, is we recognise it's not necessarily every stage that needs to be involvement, and there is a difference between police investigations and what I've described as the lessons learnt stage. But that equally, the fact that families don't necessarily have a right to be involved in police processes doesn't mean they don't have a right to be involved at the other stages, and that the question arises is what the test is. And as I say, certainly we've not been able to identify in the case law any test other than are they involved to an extent necessary to safeguard their legitimate interests.
And so that's the measure of the fairness test.
That's the test that seems to apply at this stage, yes.
And that's how you measure fairness.
That's how you measure. I'm sort of slightly reluctant to use the language of fairness because it's not really the language in Article 2 case law as I see it. But
it's the point you were focusing on.
It's the point. Yes, exactly. That's the point. Yes, and that's why in a moment, when I was sort of summing up a moment ago about what we say the tests are, to some extent, I use the language of fairness as a matter of domestic law because that's what comes from cases like Roberts. But equally, I use the involvement to the extent necessary to safeguard their legitimate interests in the context of Article 2. One thing, though, that just on that I would also emphasise from my submissions yesterday is, although the case law makes clear it's not a freestanding requirement, one touchstone by which one it measures potentially that issue of protection of legitimate interests is public confidence. And I drew attention to the case law yesterday that makes it clear that one of the purposes of the Article 2 investigative obligation is to ensure that there is public confidence in the rule of law. And so looking at and going back to the distinction I just drew between police investigations and lessons learnt investigations, is it going to undermine public confidence that family aren't involved in a police investigation? We would accept it won't undermine it because it's normal practice for the police to conduct their investigations in private for good reason. Does it undermine public confidence if the family aren't able to raise issues they want to raise in a process like the CRE investigation? It does have the potential to undermine that because it looks as though effectively the analysis essentially of what lessons need to be learned is being conducted in secret. And that's where, and so public confidence is important. It's not a freestanding test. I'm not suggesting it's a freestanding test, but it is part of the context in which one should look at that issue. And that's the context in terms of the second thing I wanted to come back from yesterday, which is the question being, how can a special advocate assist in a manner that the counsel to the inquiry cannot? Can I just say that I think in answering those questions yesterday, I, perhaps for understandable reasons, focused on the sort of, in one sense, the principled arguments regarding that, rather than the specific arguments in the case. And I think I would submit, and we've made this point in our written submissions, it is important not to lose sight of the fact that the core participants I represent obviously do seek the instruction or the appointment of Ashley Underwood, King's Counsel, and his junior, based on their previous experience in the case. Now, Mr. Underwood, just to put this in context, first became involved in this case about 12 years ago. He was first instructed, in fact, he was first instructed as the open advocate in the case in about 2013. He was instructed as the open advocate and then became the special advocate when the initial special advocate was appointed to the High Court bench in Belfast. That means that certainly as far as the families are concerned, they both believe he has a depth of knowledge of the case and they have confidence in him. They believe he is an effective advocate on their behalf. And that is important, obviously, we submit, particularly in the context of a case where the reality is, obviously, a lot of the material is, a lot of the issues are going to be considered in private. Now, obviously, the terms of reference are wider than the issues that were found to be arguable by Mr. Justice Horner, as he then was. But one shouldn't lose sight, for example, of the fact that all of the issues that were found to be arguable in terms of state failings, grounds 2, 6, 7, and 9, all essentially related to intelligence. That means sensitive material was likely to be central to all of them. That means we would submit that it's not surprising that there is a belief that among the families that Mr. Underwood must have played a significant role in achieving this public inquiry. And that's in part why confidence, and I've made the point that it's not a freestanding issue, but it is the context. Confidence issues arise in this case. Now, when I think the inquiry broke yesterday, I was making submissions about one particular important role being effectively confirmation of whether or not there were grounds of challenge. And one of the things that I think I should have made clearer, perhaps, or certainly should have addressed, was that, of course, when one talks about potential grounds of challenge in this context, one's not necessarily just talking about a challenge at the end of the process. Grounds of challenge can arise in relation to decisions made regarding disclosure. And one of the problems, for example, we discussed, there were submissions yesterday on disclosure, and you fairly put to me, sir, I think, that counsel to the inquiry will, of course, be arguing for disclosure. But suppose there is a situation which is, we would submit, not unrealistic, where counsel to the inquiry argues for disclosure. The inquiry rejects those arguments, having heard argument from state court participants. It may be there are arguments that the decision in those circumstances are flawed. But the family court participants will have, without a special advocate, no way of knowing whether that's the case. And having a special advocate, particularly an experienced special advocate who has their confidence, like Mr. Underwood, who doesn't at any stage say there is a problem in relation to disclosure, as he would probably be, well, as he would normally be entitled to communicate, gives people confidence that effectively the disclosure process is working as it should do. I mean, the problem would be without that. I mean, counsel of inquiry may strongly believe that their arguments should have been accepted, that there's a legal error in rejecting them, but there's no obvious way that that can be advanced because their duty is to the inquiry. If there were to be a judicial review in those circumstances, they would probably have to defend your ruling. So, and perfectly properly that. And that's one of the reasons why if you look at that, using the test, if one considers the test I just outlined, which is safeguard their legitimate interests, they have a legitimate interest in ensuring that everything that should be in open is in open. Public confidence depends effectively on that. And if there is an independent mechanism, effectively someone representing their interests, who is able to assess essentially whether there is legal error in the approach that's being adopted to that, it gives confidence. And remember, as I say, the point, there is also an inequality, which is that state court participants will be seeking to withhold that material. Should you order disclosure, it would be open to them, potentially to bring judicial review proceedings. It would possibly be open to Sir Ronnie Flanagan to bring proceedings if he's party. And I'm going to come on to the issue of Sir Ronnie Flanagan because it is particularly important in a moment. But all of those things, but the families wouldn't have that safeguard, which, as I say, state court participants would have. They would be able to understand your reasoning. They would be able to assess it. If they felt it was appropriate, they would be able to challenge it.
There's something I wanted to ask you about in relation to Mr. Underwood, and
yeah.
Since you mentioned him, this is perhaps as good a point as any to do it. I understand very well why you would like the appointment of Mr. Underwood and Mr. Kennedy, given their previous involvement
yes.
In the proceedings. But in terms of the process, you correct me if I'm wrong, but as I would understand it, the relevant law officer would identify a list of suitable counsel.
Yes.
And he would then make that list available to the parties, to the court participants, and they might be given the opportunity of choosing from within that list. But in order for any individual special advocate to be put on that list, the law officer would have to be satisfied that it was appropriate to appoint that individual.
My sort of experience of the process is rather that what normally happens is that the full list is made available to the parties. They identify people they want on it, and it then goes for tainting at that stage. So you might say, I would like person X off that list. It goes back to the security services for a tainting check.
Well, you'll appreciate that I've seen the closed Horner judgment,
yes.
And also the closed material that was presented to the judicial review.
Yes.
And if, hypothetically, there was intercept material included within the closed judicial review proceedings, then that material would have been disclosed to the special advocates by virtue of paragraph 7 of Schedule 3 to the Investigatory Powers Act.
Yes.
Now, if we assume for a moment that special advocates were appointed in the inquiry proceedings in relation to an ordinary restriction order, then they would, of course, receive disclosure of the material covered by that order.
Yes.
But intercept-related conduct could only feature in the inquiry if a restricted proceedings order was made, as contemplated by paragraph 23 of the schedule.
Yes.
Now, one conceivable outcome of these hearings is that I conclude that a special advocate may be appointed for hearings in general conducted under the authority of Section 19, but that no such special advocate may attend at restricted proceeded hearings as governed by Schedule 3. Now, in the event of that outcome, would Mr. Underwood and Mr. Kennedy not be tainted on the assumption they had seen material in the judicial review proceedings which would not be available to them in the inquiry proceedings?
Well, two things. Firstly, just, and this isn't answering your question, but it might minimise the risk of that. We would certainly submit that obviously the 2016 Act needs to be potentially read compatibly with Article 2, and if the appointment of Mr. Underwood and Mr. Kennedy was necessary for public confidence, the interpretation we gave, or we've argued for rather, in relation to the sort of catch-all provision, I can't remember the provision, but you will remember what I've described as catch-all provision should potentially incorporate them. But let's assume for the moment that argument is rejected, and the tainting process ultimately is normally concerned, as I understand it, with the idea that because a special advocate will normally spend time in open, it's important that they don't have knowledge of something that they may inadvertently divulge that is meant to remain secret. In this case, we have expressly accepted, of course, that for Mr. Underwood and Mr. Kennedy to be appointed as special advocates, they wouldn't be able to go through an open process because of the knowledge they've got. It's difficult, we would submit, to see why they should be disqualified on the basis of knowledge that they've got that is sensitive, but that that they've got that is sensitive, but which they couldn't effectively deploy in closed proceedings. I mean, they have that knowledge. They're expected and understood to be able to do other work without, despite having that knowledge, because I mean, the concern normally is underlying this process is that they will disclose something inadvertently to the people who can only remain in open, and because they won't have contact, it's difficult to see how that's the issue. But one of the problems anyway with the tainting process is ultimately there is a veto effectively for the security services in relation to this, and I don't know how that would play out. So, but in one sense, it would be speculative. We would submit to essentially refuse to appoint them in these circumstances where we don't know whether there's an objection, don't know whether it's a legitimate objection from the security services.
So you say that might not necessarily be an impediment? It
might not be an impediment, because, as I say, certainly my understanding, and I am effectively, perhaps in one sense, giving evidence, but certainly my experience of the tainting process is that tainting process is about ensuring that material isn't disclosed to someone who isn't security cleared inadvertently. Can I then, I think I've probably covered to some extent what we say the role of the special advocate will be, and I think I've touched those. I have touched upon, though, on the position of Sir Ronnie Flanagan and its relevance, but I think I need to be clear about what our position is, because it is, in our submission, of real importance when looking at the issues of fairness and looking at the issues of effective participation. Sir Ronnie Flanagan's letter, or the letter written on his behalf, dated 15th of April this year, makes it clear that because of his prior knowledge of some of the sensitive material, he seeks to participate in closed proceedings. And we recognise that it may be difficult to, well, say difficult, that suggests as though you might have a sort of underlying intent, but we recognise rather that the terms of Section 19 suggest that he should be potentially able to participate in the closed proceedings. On the face of it, if he has the necessary security clearance and he has the knowledge of closed material, it's difficult to see what justification there is for excluding him from a closed process. Now that, if that is correct, it does create, we would submit, an inequality in circumstances where obviously there have been criticisms made by family court participants in the past of Sir Ronnie. And as I say, it's not simply that he is in a position to, for example, question through his lawyers witnesses when the family court participants aren't. He's in a position to assess whether there is any challenge he would wish to make to rulings of the inquiry, particularly including in relation to disclosing things into open, and also on the substantive merits. He has that advantage, which, without a special advocate, we submit the family court participants will not have. Now, of course, there is a second alternative, which is that although we've said it would appear difficult to see what justification there is for excluding him, if he were to be excluded, that potentially makes it difficult for counsel to the inquiry, because they would then potentially have to question on behalf of parties who have conflicting interests. And that may be an issue anyway, because obviously, as is clear, family court participants, although largely aligned on many issues, are not completely aligned. And the position of Ronnie Flanagan does add a complexity to this case, which perhaps wasn't present in some of the other cases, and we would submit in summary either poses a problem in the sense that it gives a perception that he as an individual court participant is an advantage, or it causes a problem for the counsel to the inquiry, because they then have to look after the interests of a number of people who are excluded from the closed proceeding, who have potentially quite conflicting interests. And that last point about conflicting interests does mean in our submission it is difficult to draw any assistance from the comparison that is drawn in some of the pleadings to the role of counsel to the Investigatory Powers Tribunal. The statutory framework and the context is very different. In a complaint to the Investigatory Powers Tribunal, what will happen effectively, certainly seems to be envisaged by the rules and seems in practice to happen, is that an individual will submit a complaint against the security services. The security services will be able to present their material confidentially, and the individual will quite often be excluded from that process because of the need to protect security. So that it's not multifaceted in the way that an inquiry such as this is. There is one person excluded and one party that is able to attend and present their case. And in light of that, it's not surprising that effectively, although the position is named counsel to the IPT, it quite clearly has specific, the counsel quite clearly have specific duties to protect the interests of the person who's made the complaint. So it may be worth just looking at the framework, because it is very different to the framework in this case. If you go to the authorities bundle, tab 4, page 39, this is section 69, which is the rule-making power in relation to the tribunal. You will see in subsection 3 that the rule-making power, particularly subsections B and C of subsection 3, the rule-making power is specifically established to enable the protection of the complainant. And the rules, and this is quite a different rule to the rule that obviously applies in this context, the rule is then tab 10, page 104, the relevant rule that provides for counsel to the tribunal. And you'll see that although there is a broad discretion to appoint a counsel to the tribunal, the 3 specific circumstances in which the power arises are all ones where effectively the complainant is at a disadvantage and the functions of counsel to the tribunal in addition to sort of perhaps what one might expect, including things like pressing for disclosure, specifically require the counsel to the inquiry to identify any arguable error of law in a decision of the tribunal. And so although they are described effectively as counsel to the tribunal, they are specifically required to effectively provide the safeguard that we submitted is particularly important about identifying whether there is some basis for challenging the conclusions of the tribunal. And that contrasts in our submission with what the role of counsel under the inquiries rules. The inquiries rules obviously contain less detail about what the role of counsel is. The rules themselves essentially provide, as you'll be aware, the relevant rules, I think it start at page 55, but you probably don't need to go to them, that under Rule 2, it's you who appoint chair. They ask questions effectively on your behalf. That's Rule 10. There isn't any further guidance on it, but as you'll be aware, we put it in our application. We haven't produced it because it is only in draft. The Cabinet Office have suggested that effectively questions are being asked on your behalf, and legal advice is being provided to you by counsel to inquiry. All of that indicates that unlike the investigatory powers
Would
tribunal,
that legal advice not include the question of whether or not I'd made an error?
well, but the point about, I mean, obviously, if counsel to inquiry believes you have made an error, I would expect them to give you that advice. But what we're talking about here with counsel to the investigative powers tribunal goes beyond that, in that the whole point of it is that it's not just whether you've made an error, it's whether the tribunal's made an error. It's about whether there's an arguable error, and there is then a process essentially, and I didn't perhaps highlight that, I should have done.
I understand it, that there is a process for bringing that to the attention of the court.
So yes, exactly. And it would be, as effectively your legal advisor, it would be a very odd position for counsel to the inquiry to be in a position, and this is what effectively would be required, would be counsel to the inquiry to say to you, well, I think the law is X, but there's an argument that the law is Y. If you adopt X, I've then got to tell the court participants that although you've ruled X, and I will argue in the High Court it's X, I believe there's an argument of Y. That's a very odd position to be in, and it's a very uncomfortable position we would be in, and it would certainly need some sort of authority, which is what you see in relation to the IPT. And it goes back to the point I made earlier, which is that if counsel of the inquiry was some sort of panacea, why is this room full of all the lawyers that are present? And in part, I mean, we would submit, in part, that's for two reasons. Firstly, and one shouldn't lose sight of that, even if it's a situation where, and in relation to a case like this, or an inquiry like this, in open, this may often be the case, but even if court participants can't bring any particular knowledge about a topic, obviously lawyers can potentially identify, based on the evidence, issues to be investigated. But secondly, and probably equally importantly, if not more importantly, they provide a safeguard from the court participants' point of view. They're able to advise as to whether or not there are flaws in the way in which the matter is proceeding. And as I say, that second point becomes even more important when matters go into closed, because there is then a very important issue from the family's point of view, which is actually, is there a proper legal justification for withholding material?
Some might say that it begins to sound a bit uncomfortable if you start with the premise that you have full confidence in the inquiry, in the independence of the inquiry, the independence and competence of the chair and the team, and yet the core argument in favour of a special advocate is to ensure they don't do something wrong.
Well, I wouldn't necessarily accept that because obviously, as I submitted yesterday, the best inquiry in the world, the most able lawyers in the world make errors. We all make errors. And
well, I understand that, but I'm just wondering just how far that goes. I mean, one wouldn't, for example, contemplate just a secondary process of representation just on the off chance that somebody along the line made a mistake. And I'm just wondering how it might sound to others, to observers, to hear the proposition that everybody thinks the inquiry is independent, everybody thinks that the inquiry is capable of doing a good job, everybody thinks the counsel to the inquiry are experienced in this field, everybody thinks they're very well qualified, everybody thinks they're very diligent, but we need this second tier of representation just to make sure they don't do anything wrong.
But I do draw the analogy with, or I do make the point, as I just made, that all of those things would apply in open. But if they're if they're sufficient, effectively, to enable, to use the Article 2 language, the families to safeguard their legitimate interests. In one sense, why am I going to be here for attending hearings, for example? The reason for that in our submission is in part because, as I say, fundamentally it's for two reasons. One, it's because it gives a voice to families who can advocate for certain things during the process, who can seek to have questions asked, etc., etc. But secondly, it is just it gives them reassurance if they are advised, and that's likely to be the advice, if they are advised actually this process, even if you're unhappy with some of the findings, is a proper process, it's a reliable process, etc. It gives reassurance. And that reassurance, the reason I'm focusing on that is that if you think about the realities of this case, or this inquiry, everyone recognises that large key parts of this process are likely to be enclosed. Now, that is likely to be frustrating, despite all the points you've just made. It's frustrating for the individuals because they want to know the truth. They want to know that whatever findings are made are reliable. They would normally be able to do that, in one sense, by attending, by viewing, by making sure that they see what questions are asked, they understand what's been said, they can follow the process, and then have confidence in the outcome. When things go into closed, they can't do that. But if they have someone who they have confidence in, who is present, who is effectively saying there is no problem here, that adds to confidence in the process. Particularly in circumstances where, as I say, the state parties are present, the state parties will have that advantage. And as I say, it's not about doubting anyone's competence, anyone's commitment, anyone's integrity, or anything along those lines. It's about a process which is inherently frustrating, inherently limiting the participation, the legitimate participation of the family members, and as a result, and the need for confidence in that process. And it is striking, as I say, that there's been a special advocate involved in the judicial review. There is likely to be a special advocate involved should it proceed to trial in the civil claim that's, and I think you're aware of the civil claim that challenges the adequacy of the investigation. Certainly that has been raised as being a possibility during hearings this year.
But that's only striking if you don't take account of the difference between the adversarial and the inquisitorial nature of the proceedings. It's not really fair just to merge them all together like that. These proceedings are not in any sense the same as the judicial review proceedings, where all that was happening was that a contested claim was being argued to a point of arguability, not even to a point of determining. And once the bar of arguability had been reached, it was handed over to an entirely different process to carry out an actual independent investigation into those matters. So it's a completely different process. Now, I readily understand why you say you would like to have a special advocate in these proceedings, but I don't accept that it's striking that there might not be because of the difference in the two sets of procedures.
Well, except, and this is why I was drawing the analogy, is this, that in one sense, if you focus on the judicial review at the moment, because obviously that happened, in the judicial review, why was a special advocate needed? A special advocate was needed to ensure that, firstly, as much as possible was put into open. That is a role or that is a function that needs to be undertaken. I accept, obviously, counsel to the inquiry will seek to perform that role as well, but the special advocate, as I say, has advantages, including the advantage that they are able to say to the families, I think there's been a flaw or an error in the approach that's been adopted to that. Special advocate was there to advance arguments about what the closed material shows. Those arguments are potentially important from the family's point of view in the context of the inquiry. While obviously the counsel of the inquiry will be seeking to will undoubtedly make submissions about what the material shows, they are not specifically instructed effectively to advance the interests of the family. They will have to balance, they will potentially have to balance the interests of others, such as I've already indicated, Sir Ronnie Flanagan. In the judicial review, they had the advantage of being, the special advocate had a potential role, had the judicial review been rejected, of advising on appeal or indicating whether there were closed grounds of appeal. And that role, as I've already indicated, is potentially, it's not obviously an appeal, but it's a judicial review, but that role potentially is also of importance in this context. So the analogy I draw is because the function, although the process is different, the functions that a special advocate potentially would need to perform are similar. Now, one thing that has been touched upon by counsel of the inquiry is why is this inquiry different to other inquiries where there hasn't been a special advocate? And one firstly needs to be a little cautious about looking at other inquiries, partly because the rulings don't necessarily set out all the arguments, so it's unclear what arguments were presented. It's unclear, for example, if the concerns I've just raised and raised on a number of occasions about legal advice were raised in those other inquiries. But what are the differences? Firstly, we would submit that one shouldn't lose sight of the context of Northern Ireland, the particular concerns or suspicions about the position of the state, which are enhanced in this context, we would submit, by the fact that it has taken so long to get to where we are now. Secondly, there is the history of the use of the special advocates, and of course, Mr. Justice Horner did seem to suggest that they might be appointed in the inquiry. I recognise that there is a very real limit to what weight can be placed on those remarks of Mr. Justice Horner. They were formerly obiter. I obviously have the advantage of knowing what was argued. I don't remember anything being said in argument about the use of special advocates. I don't know whether there was any. Certainly there was reference to the need for a closed procedure, but I can't remember whether anything was said about special advocates. But those remarks do suggest that Mr. Justice Horner, who had obviously seen the special advocates function, and you, sir, obviously have an advantage over me in the sense that you have seen the closed judgment, but they do suggest that he regarded the role of the special advocate as being of an advantage. Another significant difference is the potential central role of closed material. I mean, to use the Manchester example, obviously Manchester, there was an important closed issue, I can't deny that, but equally there were plenty of fully open issues. Here, the terms of reference we would submit on a fair reading make it clear that closed is likely to be at the heart of almost all, if not all, of the key issues of preventability. There is then the issue of the sort of the potential conflicts that arise because of the position of Sir Ronnie Flanagan. And finally, what we do submit, because of the need potentially to reflect public confidence, we do submit that it's appropriate to take account of the fact that it is clear that a number of the call participants clearly have very strong views in favour of the appointment of a special advocate, which links back possibly to the previous role played by special advocates. The issue of delay has been raised. How significant delay is in our submission is perhaps difficult to assess at this stage. It may depend, for example, on who's been appointed. If the special advocates from the judicial review are appointed, potentially in conjunction with somebody else, they clearly bring a significant amount of knowledge of the closed material into play. That's likely to speed matters up. They've also been sought at a relatively early stage. As far as my understanding of what the inquiry has said about listing, at this stage, we're still at a stage where there are no closed hearing dates. But in any event, in our submission, if I'm right that the tests are as I've described, which is whether the appointment is necessary for fairness, whether it's important to ensure that the legitimate interests of the court participants are protected, in our submission, delay can't be a justification for refusing to appoint special advocates. Now, one aspect that has been touched upon in relation to the delay is the particular issues that arise in relation to the facilities available for special advocates in Northern Ireland. I think you're aware, that there is an ongoing judicial review, it's still ongoing, that challenges the resources that have been provided to special advocates in Northern Ireland, and I'm instructed for the applicant in that case. The latest position on that, because there's been recent correspondence on it, is that there is still no firm date as to whether, when SASO will have dedicated premises in Northern Ireland for special advocates to view papers. However, we would submit, it's unclear why
is the intention that they will have dedicated premises?
It is, yes, there is a commitment to provide. I'm talking from memory at the moment, but the plan is at the moment that they hope to have premises that are signed off by the end of the year, I think it is. It has to be, the premises have to be modified, as I understand it, and then have to be approved by the security services, as I understand it. But there is no firm date, I accept that. However, what is clearly happening at the moment is that special advocates are effectively using the premises of PSNI and the MOD, as I understand it, to view materials. Presumably, the inquiry, because otherwise it's difficult to see how it could function, has facilities available to it that enable security sensitive material to be viewed. It's difficult to see why a special advocate can't view the material there. And clearly, the issues that arise, although they have caused delay, are not preventing progress being made in closed procedures. And in this context, where it is victims and survivors who seek the appointment of a special advocate, it is a bit, we would submit, well, it doesn't sit well for effectively state parties to say, well, they'll be delayed because of the failure of the state to provide resources to enable special advocates to fulfil their role. But as I say, in any event, we would assume, and this is something as open advocates may be difficult for us to understand, but we would assume that whatever facilities are available to the inquiry could be used by special advocates to view papers. I've made reference, obviously, to the appointment of Mr. Underwood and Mr. Kennedy. I've argued why they would be of an advantage. We recognise that, of course, one of the problems with them being involved is that while some core participants have been able to instruct them and have had, in the past, meetings with them, etc., giving them instructions, that isn't true of all core participants. The solution to that we've proposed, based on experience of other cases where there's been a development, a very significant development, which means further instructions need to be given, is that an additional special advocate can be instructed to effectively join the team. And that means that there is an opportunity for that additional special advocate to be given instructions in open. They then join closed, and you have a combination of updated and fresh instructions with the prior knowledge of the existing special advocates.
So does that mean there would be 3 special advocates?
You would either, what's actually happened in some cases I've been involved in is, and I don't want to do Mr. Kennedy out of a brief, but junior special advocate has effectively been dismissed. A new special advocate, junior special advocate, is brought in replacement as a way of getting instructions so that they can work with the senior who's got knowledge, or you make it 3, which would not necessarily be disproportionate given the value of the volume of the material. But one way or another, what you're looking to do is bring together the existing knowledge of the special advocates, which is of value, with someone who can come in from open and bring in fresh instructions from those who haven't been open. And that's a mechanism, to say, that certainly I've experienced in practice. The final issue that's been raised in terms of practicality is the issue of cost. Now, I should say, in terms of cost, as with other issues, our basic point is that practicality shouldn't drive the outcome of this. Practicalities there must be a solution to these. If you look at the cases, one of the things that you can potentially draw from cases like the Queen and H, where there was no system in place, was that ultimately a solution was found to practicalities because fairness required it. And the key question is, what does fairness require? What does Article 2 require in this context in our submission? And if it requires the appointment of a special advocate, solutions have to be found to these issues. Correctly, we submit, PSNI in its submissions recognises that, in general, it's the public agency that's seeking to rely on closed material that ends up paying for the special advocates, but says there's a distinction because these are inquisitorial material. In our submission, the problem with the PSNI submission, not in one sense, it perhaps makes very much different from an applicant's point of view, because ultimately we would say the state has to fund this in one way or another if it's needed for fairness. But the problem with the PSNI submission is that actually the test, and one sees this from T, it may be just worth looking at this because it makes it good. If you go to page 897 of the bundle, which is tab 33, T was a case where there was a question about who pays for the use of sensitive material in family proceedings, the use rather of a special advocate in family proceedings. And the ruling ultimately of Mr. Justice Cobb was, as you see at para 28, was that it was the agency that held the material that should pay for the special advocate, and that was the police. And the police obviously aren't a particular party. It's not like, for example, SIAC, where the state is bringing proceedings against the individual and wants to rely on closed material. Ultimately, in the family proceedings, the reason the closed material was needed was because the court had duties to ensure that the best interests of the children were being protected, that it wasn't a situation where, if you like, the police were raising a positive case. And ultimately, in our submission, that must be the correct approach, because if one thinks about what will happen in this case, the reason why material will be confidential is because the inquiry has concluded, for legitimate reasons, one assumes, but the inquiry has concluded that an application made by a state party for a restriction order is a valid one. It's the state that is seeking to benefit from the restriction order by protecting its, and it seeks to benefit from it because it seeks protection of its legitimate interests. And if that requires additional cost, then it should be the state, because it's the state that's seeking to withhold the material, that's paying for the special advocate. But as I say, we submit, in one sense, that can't drive matters. The key issue is what does fairness require, or what is required to ensure that the legitimate interests of family members are protected. Final thing I should say is, you'll notice that I haven't gone into any great detail about the judgment of or the decisions rather that were reached in the 3 inquiries where consideration has been given to the use of special advocates. The reason for that is that although obviously in one sense, two of them might be said to be supportive of my arguments because two of them obviously found that there probably was a power. We recognise that ultimately they're not binding. It's unclear, certainly from our reading of the decisions, what arguments were advanced. Looking at where we are now, you will have, by the time this hearing finishes, have had extensive arguments about a number of issues, some of which don't seem to have been considered in the earlier inquiry decisions. And so you hopefully will be, if the Council have fulfilled their task, will be in a better position to consider these issues than perhaps previous inquiry chairs were.
I think that's undoubtedly going to be the case,
Yeah.
Mr. Sully.
So that's why I haven't spent a huge amount of time on, because ultimately, I hope you'll be in a better position to reach the correct conclusion, whatever that may be.
Well, I think I agree with you entirely on that. There's just really not enough in the decisions themselves to gain much insight about what the reasoning was. There's a small matter, though, that I did want to bring to your attention, just in case it's of any significance. I don't think it is, but in paragraph 35 of your own submissions, you draw attention to what was said in the Afghan ruling about Sir John Saunders' reliance on AHK.
Yeah. Sorry. Yes.
Now, you then deal with the impact that Al-Rawi has on that, which is not the point that I want to draw to your attention. There's a quote in paragraph 5 of the Manchester Arena inquiry decision, which is said to be from AHK, and it's that quote that's then referred to by the chair in the Afghan inquiry. All I want to bring to your attention is that, as far as I can see, the quote doesn't in fact come from AHK at all. It comes from the second first instance case in the Competitions and Market Authority series of litigation.
Okay, I don't think I spotted that. As you say, I can't see why that would make any
difference.
Yeah.
But I just wanted to make sure that we didn't go through this whole procedure with that not being identified.
Yeah. No, I don't think I spotted that, but I don't think anything matters in relation to it.
And it doesn't add anything. The judge in the first instance Concordia case was His Honour Judge Matthews. He gave an extempore judgment, and there was no authority cited.
Yeah. Yeah. Thank you. Thank you. That covers everything. Sorry, Ashton.
Could I just ask you about one final thing there,
yes.
please? You mentioned during the course of this morning's discussion that a significant part of the consideration, which I should bear in mind, concerns the issue of public confidence.
Yes.
And I understand why you make that point. But you say, and I think rightly, that it's not something which is a standalone consideration.
Yes.
And does the same apply then to the interests of the next of kin? In other words, that they're not a standalone consideration. And the reason I ask that is because, as we discussed yesterday, the requirement under Article 2 is to provide, in the language of the European Court, some form of effective investigation.
Yes.
And a component of an effective investigation is obviously the involvement of the next of kin.
Yes.
And they require to be involved to the extent necessary to safeguard their legitimate interests. That's the test we've been canvassing.
Yes.
So that's a component of an effective inquiry. But the fact that involvement on the part of the next of kin is but one component then raises the question of what weight might have to be given to that component as compared with others. And I want just to ask you to look with me at Safi against Greece. It's again a point that's been made a number of times, I think, in the European Court. And it's a 2022 decision, paragraph 116. And it says, in exactly the same language as has been used elsewhere, most recently in the Ukrainian case from 2025 that we touched on. The passage is, the court considers it appropriate to specify that compliance with the procedural requirements of Article 2 of the Convention is assessed on the basis of several essential parameters: the adequacy of the investigative measures, the promptness of the investigation, the involvement of the deceased person's family, and the independence of the investigation. These elements are interrelated, and each of them, taken separately, does not amount to an end in itself, as is the case in respect of the independence requirement of Article 6 of the Convention. They are criteria which, taken jointly, enable the degree of effectiveness of the investigation to be assessed. Now, there's nothing to quarrel with there, is there?
Well, I'm not going to disagree with the. Well, I'm not going to disagree with the European Court of Human Rights, certainly at this stage. What I would say about that is that that is in broad terms expressed as because what's being said is you look at matters such as the involvement of the family. The case law does, and I took you to but there's Strasbourg case law, Strasbourg judgment after another, that the case law does go, we would say, in relation to the family, a little more specific in the sense it does repeatedly use this language of involvement to the extent necessary to protect legitimate interests. It's difficult in those circumstances to see how, for example,
that's the very language used in Safi.
Well, I don't have it in front of me, but I thought it was slightly different in terms of the family.
It's compliance with the procedural requirements of the Convention is assessed on the basis of several essential parameters: the adequacy of the investigative measures, the promptness of the investigation, the involvement of the deceased person's family, and the independence of the investigation. It just seemed to me that the question then comes to be, does that mean that fairness is a question of balance?
Well, see, the reason firstly just that I made the point about language is that the language there is simply, you look at is talking about the involvement of the family. Now, if you look at those parameters, taking another of those, independence, while there may be a degree of overlap, as the court says, and each in their own is not an end in itself, to use that language, it's quite clear, Ramsar being an example, that you can have violations simply because an investigation isn't independent, to use that as an example. Ramsar, you may remember, was the one where the police, the initial police investigation was conducted by the police force that was being investigated. So that paragraph, but it can't be read as meaning you can't find a violation effectively on the basis of individual, any of those individual criteria. And simply, and we would say, because it's been said repeatedly, similarly, if there's insufficient family involvement, that is a standalone basis. That was effectively the basis upon which the challenge succeeded in Amin. Now, yes, there is a degree of overlap. Yes, there is a degree of balance, because we've accepted, for example, that the requirement for legitimate involvement doesn't mean you can't have a closed procedure. But the balance comes in because once you depart from, if you like, the normal model, and the normal model being attendance, that's the way, as a matter of domestic law, we comply with Article 2 within the United Kingdom. If you depart from that, you need safeguards in place that ensure that, those interests, those legitimate interests, are safeguarded. And that's the way in which in our submission one needs to assess it. Yes, it's not one model fits all, and there's plenty of case law that makes that clear. But if the state is departing from normal standards, safeguards need to be put in place that ensure that basic principle of legitimate interest is safeguarded. I hope that answers the question.
It does, yes, thank you. I'm most grateful to you, Mr. Southey. Your submissions have been particularly helpful.
Thank you, my Lord.
I think it would probably be helpful, Mr. Greene, if we take a short break.
It would be helpful, so yes. And when we return, there's going to be a change to the running order, in that for good reason we will hear next the short submissions of Mr. Scales on behalf of Sir Ronnie Flanagan.
Good morning, Mr. Scott.
Morning, sir. Thank you very much, and also thank you to my colleagues for accommodating me out of order. I very much appreciate it. Thank you. Thank you. On behalf of Sir Ronnie Flanagan, sir, we have considered in detail the submissions made by the other core participants, both from the victims and also from the state agencies, together with the very helpful documents from the inquiry's legal team. Sir Ronnie has read with particular care the submissions by the victims groups, particularly where they seek the appointment of special advocates. I should make this clear, that he is entirely sympathetic to their requests and acknowledges why they seek and why they feel that there is a need for the appointment of special advocates. And Mr. Southey has already covered that in some detail, but it includes, of course, ensuring that everything is done to put information into the open. And if there has to be a closed process, then it should be, as seems likely, as limited as possible, and secondly, to ensure the interests both of the victims and wider public are protected within those closed proceedings. And nothing I say on Sir Ronnie's behalf should be taken to undermine any of the submissions made by the victims groups, and indeed I note that in some respects, for example, in Mr. Southey's submissions, reliance was placed on Sir Ronnie's position in support of the submissions that the victims have made. So, as you will have seen from our short submissions, Sir Ronnie does not himself seek the appointment of a special advocate, subject to one caveat that I'll mention in a moment. It's very important, lest it be misunderstood, that Sir Ronnie's submissions on the appointment of special advocates for him reflect his position as having been the Chief Constable at the material time of the bombing, thus having had the authority at that time to view much of the closed material. That puts him, it may be thought, into a slightly different category. And we submit, sir, that it's not unusual, in fact, at all, for somebody in his position in a later inquiry to have some role in closed proceedings, necessarily dependent on the individual circumstances of an inquiry and the issues that a witness or a core participant has to address. With respect to the questions that we were asked to comment upon, we do not intend to add to the extensive submissions you have in writing and orally on whether special advocates can lawfully be appointed, and indeed by what process, and we mean no disrespect by not adding to that weight of learning. The central point we make, sir, is this, that if there is a power in law to appoint, that should only be exercised where it is necessary to do so. And that in Sir Ronnie's case, it is not necessary to appoint a special advocate to represent his interests. And therefore, in the absence of there being such a need, there is no justification for appointing one, certainly at least not at this time. The basis for that submission is, as I've alluded to already, Sir Ronnie is in a somewhat different position to the other non-state core participants at this inquiry on principally the issue of the protection of sensitive information. As the Chief Constable at the time of the bombing, Sir Ronnie is likely to have had authority to view the majority of the closed material back then. Further, he may well have seen some of the actual material to be considered enclosed at this inquiry. He may be required to give evidence in closed proceedings, and we respectfully submit that as a requirement of basic fairness, if he is expected to give evidence in closed, he cannot simultaneously be excluded from those same closed proceedings. Moreover, and this has been touched on already, I think, through Mr. Southey's submissions, if there is material on which findings may be made which touch upon directly or inferentially Sir Ronnie, he is required to be given some notice of it and the ability to comment on it. Of course, we cannot know at this time whether he will be required to give evidence in closed, or whether there is material to which he should be given some access. But for the reasons I've just summarised, we respectfully submit there is no basis to exclude him from those aspects of closed proceedings that are relevant to him in the way that I've already summarised, and therefore there is no necessity for the appointment of a special advocate for Sir Ronnie. We acknowledge, of course, that there may be classes of material in the closed proceedings that he did not have authority to see even when he was Chief Constable, and cannot properly be shown now, although of course that cannot be known as yet. We acknowledge, of course, that the state core participants will have legitimate concerns about the control of sensitive information, but in Sir Ronnie's case, we respectfully submit that is capable of relatively straightforward, conventional case management, and orders around such matters as document handling are entirely commonplace in inquiries that have a closed element to them. And as we have alluded to in our short submissions, written submissions, members of the legal team representing Sir Ronnie would, we anticipate, have the necessary clearance level to see the closed material, or the majority of the closed material in this case. So should you agree with our analysis, again, to make it entirely clear, Sir Ronnie is content that the inquiry legal team deal with the issues in closed, but that any closed material which is relevant to Sir Ronnie is brought to his attention. We refer to Sir Ronnie here, meaning both him and his suitably cleared legal representatives. That would, we submit, mean Sir Ronnie has some involvement in closed proceedings, should there in fact be the material that requires his input, but only on a limited basis. Similarly, if he is asked to give evidence in closed, then he should be cited on the material relevant to that process and be legally represented. None of those submissions, we hope, suggest or are intended to suggest that an adversarial approach is taken to this inquiry, nor that Sir Ronnie is himself taking an adversarial approach to this inquiry. We respectfully envisage that Sir Ronnie's role, as described, can be readily managed on an ongoing basis. And again, if that is right, we submit there will be no necessity for a special advocate to be appointed for him. For the avoidance of doubt, we do not hold the view or make the submission that Sir Ronnie and his legal team should be given access to all the closed material. It is only that would touch on him and his necessary level of involvement in the closed process. He has no interest in having wider access to or sight of all of the closed material. We are particularly mindful, sir, that the appointment of special advocates necessarily carry advantages, but they also come with difficulties and restrictions, many of which are very helpfully summarised and identified in the inquiry legal team's notes on the issue of appointments of special advocates. I needn't repeat those. But certainly in Sir Ronnie's case, and again I focus entirely on him, for a special advocate to be appointed for him, we envisage that those restrictions are likely to cause more problems than the appointment of a special advocate would cure, and that properly managed he can have a level of involvement in closed proceedings that are free from the restrictions that arise from having a special advocate appointed on his behalf. So, but for those reasons, we do not respectfully see the necessity for a special advocate to be appointed to represent Sir Ronnie's interests. And in the absence of that identified necessity, we respectfully submit it would be wrong to appoint one for him. However, the caveat that I mentioned earlier is this, that in the event, sir, that the inquiry decides to exclude Sir Ronnie from all closed process and from all closed information, Sir Ronnie may have to ask for some person to represent his interest in closed process beyond the assistance that would be given by the inquiry legal team. The only obvious option for that would be a special advocate. We say that position is not not necessary to be reached in his case. But if you were to go through a process that resulted in his exclusion, and also that you were minded to appoint special advocates for others, then one indeed may be mandated for Sir Ronnie. We do not wish to introduce in any way the language of conflict at this early stage, but we readily envisage that there may be difficulty in one special advocate or one team of special advocates representing the interests of the victims' groups and also simultaneously Sir Ronnie's interests. And indeed, there may be a requirement, should the interests of the victims' groups not be sufficiently aligned, for different special advocates even to be instructed for groups of victims. But we wouldn't presume to comment for them. They are all represented and can make their own submissions on those issues. So that is essentially all we would wish to say, brief though it is. We submit that there is no necessity to appoint a special advocate for Sir Ronnie, certainly not at this time. He can and should properly be granted a role in closed proceedings, although it's too early to precisely define what that is and the ambit of it, and that any security concerns arising can be easily managed along entirely conventional grounds in this inquiry and others. So short though that is, sir, I hope that's of assistance.
Thank you very much.
If there's anything we can try and assist with any further.
I'm grateful to you. Thank you.
So it would be a good idea to have a short break so that advocates can exchange positions. So may we suggest just a couple of minutes, following which we will hear from Mr. Kane, who will make submissions on behalf of the bereaved families and survivors represented by John McBurney solicitors.
All right. Good morning, Mr. Kane.
Good morning, sir.
When you're ready.
Sir, you've got the submission which we have made in writing, and we wish to rely essentially on that written submission. Further, our position is that Mr. Southey has very ably and comprehensively covered the majority of the legal points which we made, together with many others which were contained in his submission. And we gratefully adopt his arguments in those respects which support our position. And there'll be one or two matters which I will touch upon in our brief submission orally. Can I first of all, just by way of a preliminary, say that you raised, or rather counsel to the inquiry indicated that if the attorney refused to appoint a special advocate, things would get messy. And yesterday you, sir, raised the procedure whereby appointments are made. And while we've made an application for a special advocate, we do agree with your interpretation that essentially you make a request and not an appointment. And we are at ease with that. But we also say, however, that whether or not things might get messy, whether there might be legal arguments to be made, would not be a reason for the refusal of the application for a special advocate.
It was Mr. Southey, I think, who said it might get messy.
Well, my recollection is not always the best at my age, but I thought it was Mr. Greenie.
Because I raised it with Mr. Southey as a question about
Right.
Who would actually do the appointing, whether it would be me or whether it would be the relevant law officer. Now, I think we're at one. It should be the relevant law officer.
Yes.
If it's messy for him, that's his problem.
That's succinctly put,
Yeah.
sir, and I agree with that. And my apologies if I'm wrong about it being Mr. Greenie, but there you are. There was much discussion about the conflating of adversarial description and the inquisitorial role of the inquiry. Can I say, sir, that obviously that formed part of the debate yesterday. This inquiry has a huge task involving what will probably be a large amount of material which will probably again fall into the closed section. And we're content to say that, as the Act suggests, that you have to look at fairness. And much was said yesterday, many cases were cited, and the issue of fairness in various contexts arose. But we say it's for you as chairman to look at fairness, to have a feel for fairness, to consider the essence of fairness in the context of this inquiry, gleaning assistance from all the help which you obtained yesterday from the various authorities which were opened and which you may or may not obtain from what the various representatives may say to you. But we do say that we have no doubt as to the role which we have in representing our clients, bereaved families and injured survivors. And in the course of this inquiry, there will be disappointment, there will be disagreement. And that can cause an adversarial mindset to wrongly develop. But we fully accept it does not change the nature of the process. And we make these submissions to you today from an invited position to do so, to make an application for a special advocate, and thereafter we hope to assist you to reach a decision on that matter But we would, however, also invite you to take the view that it is best to go forward clothed with the support, confidence and trust of the families, feeling that fairness has been involved and is paramount in reaching the decision on the question of special advocates. We also say there are certain core values at play in this application which could potentially be at risk because of the prominence of the many legal arguments. Our application is not for some sort of trumping one argument over another. But I want to say to you this, sir, that what I say is based on firm instructions taken after lengthy and detailed consultation with our clients. And they may appear as if they're what, for want of a better word, are lay submissions almost. But they're core values which they feel are at stake. And essentially, their wish would be, all things being equal, to see all the relevant evidence after 26 years. However, if there must be closed material as is provided for by Section 19, then we say that it should, where possible, be kept to a minimum. And as I said to you, sir, in the course of my opening statement, if judgments are to be made, then close calls must fall on the side of disclosure rather than being hidden from our family's view. And I want to make this clear as well. They view a special advocate not as some extra bonus, nor as a challenge to the inquiry legal team, but as something which should be granted as they see it, as an additional assistance to them in shining light on any material which is withheld as closed by the state authorities, and to assist in the challenges to what material, if any, should be open. And they have that legitimate interest, we say, and that certainly is a matter not only of public confidence, but in particular the confidence of the families. Regrettably, the indications already given by state core participants, as referred to also in my opening statement, do little to inspire confidence in the approach of those core participants to dealing with material which is 26 plus years old. Sir, my client's instructions on special advocates were very simple, uncomplicated and easy to follow. Essentially, if it's help additional to the inquiry legal team, then they want that help as additional, supplementary and complementary. And it should not be seen as a challenge to anyone in this room or to any authority. We recognise, sir, that you have a very wide discretion. Discretion has been defined as to do as I please. Now, obviously, within this context, it's just not as wide, and there has to be an exercise of discretion within lawful parameters. But the Inquiries Act did not legislate either way on the issue of special advocates. You, sir, under the Act, control not only the procedure, but also the conduct of this inquiry. And the families look to you on this issue and say that the decision on the application of special advocates is a critical decision. It's for you to take, and it's within the ambit of the conduct of your inquiry.
Well, that's what they say. I understand that very easily. The more difficult question might be for me to determine whether or not that's the right question.
Yes, but it must be against that background. And we welcomed, once again, what you said very clearly in very simple language yesterday when you said I am not the state. And we essentially are saying to you, exercise the very wide powers which you have to assist the legitimate interests of the families in this situation. And not to look at it that it's adversarial against inquisitorial, but that it's of assistance. The point has been made that special advocates aren't necessary because of the task which the inquiry legal team can do. But we've already reached the situation where the families are legally represented. And if that argument was to take into an illogical end, then we'd only have you, sir, and counsel to the inquiry and solicitors. And what we're saying is that that, by logical extension, should mean that special advocates are granted. And the families pose a simple question to us. And we feel under a duty to replicate that to you. And that is, what's the rationale in allowing us, their legal representation, to assess material which is open and has been open to the world for years, but then seek to deny us as their representatives, the special advocates as their representatives, access to the closed material, albeit accepting that there are necessary limitations attached to the role of a special advocate. And again, put simply from their point of view, they will look around at everyone else in this room and they'll see they're all going to get into the room with the closed material and they're being excluded.
Well, sometimes what happens is that the benefit of legal representation is that legal advice can be given and procedures can be explained to lay clients. And one of the things which I'm sure you will explain to your clients is that we are dealing here not with some form of ad hoc procedure, but with a statutory procedure governed by the Inquiries Act and the rules. And accordingly, all of us, myself included, are required to conduct the proceedings in accordance with the law. So that puts a boundary and a limitation on everything that we can do. It would be a wonderful world if we could just say to the families, we are entirely sympathetic to your circumstances. We cannot imagine how difficult it must have been for you all of these years, and we will do absolutely everything we can to try and help you. We're not in that situation. We're in the situation in which the Secretary of State has convened a statutory inquiry, and we are governed by it.
Yes, and all of that has been explained, but likewise, we have great difficulty in saying, well, there's the Act that says there's no special advocates allowed. And we say to them, that's why we're having these arguments and these debates and these discussions over these 2 days.
And we'll find out what the answer is.
So that.
But the point I'm trying to make is that it's a legal answer. It doesn't depend on what my own personal preference might be. It doesn't depend upon what I would like to be able to do in these circumstances. It depends upon my interpretation of the competing legal submissions which I'm hearing, which include the proposition that there is no power to appoint a special advocate. Now, we'll see how this all unfolds. But if that's right, if it's right that there's no power, then there's nothing I can do about that. That's a legal conclusion that requires to be arrived at, regardless of whether one likes it or not, and regardless of whether it's the outcome which the families would wish, regardless of whether it's the outcome I would wish for them. It's a legal issue. And all I'm saying is that, yes, of course I understand. You tell me what the families want, but what the families can get is governed by the legal rules.
We fully know that, and the families will have had the opportunity to hear very extensive legal argument yesterday, and what they're saying is they're relying upon your judgment and the wide discretion which you have within the Inquiries Act framework.
And it might well be right that I have the power, and it might well be right that I have the discretion.
I would sincerely hope that it will be. Dealing with the practicalities perhaps of special advocates, can I just say that our submission is that special advocates do have special skill sets, born of experience in dealing with similar issues over the years, or having been involved with particular branches of state authorities over the years. And so it's not always what's analysing, what's on the table that has to be analysed, but it's what is capable of being seen as behind the material on the table. It's knowing what should be on the table, and it's knowing to ask for it. So they have a very critical role to serve on behalf of the core participants who are the bereaved families of injured survivors. And I'm not saying this as a criticism, but I'm saying this as not knowing. And that is, we do not know the scale and depth of the special advocate experience of the members of the inquiry legal team. And all I would say is that being vetted and being approved for such work does not equate with years of experience or expertise. Going on from that point, sir, I want to make a point again which I do hope is not taken by anyone in the wrong way, as we might say in this part of the world. And that is that much has been made of the expressions of confidence in the inquiry legal team. Can I say this, and it's not to introduce a discordant note, but confidence in any situation is never unconditional. And confidence is an ongoing matter, and it may ebb and flow as to the level of confidence which exists. And we have to say, and I want to be quite frank with you, sir, and that is that we put in our written submission on the 14th of April. On the 15th of April, the Memorandum of Understanding was published. I do have to say, on behalf of the people whom I represent, that that did dent the confidence of our clients in the inquiry and the decision to sign up to the Memorandum of Understanding. And that's something which may ebb and may flow. And we also say that our trust in how the inquiry will progress may ebb and flow depending upon what is essentially seen over the course of the next number of months and years. But we do also, and again, this is not to be taken as a criticism, we do also have concerns about the enormity of the work of the inquiry. And we do see our role not as challenging in a negative sense, but in assisting the inquiry. And we've already been doing that. And we have sent various queries which we have identified, for instance, in the tranches of documents, where we have identified documents which were incomplete or missing. We don't view that or do that out of criticism or lack of confidence, but we do that to assist. But the point that I'm making is that it's not unconditional confidence. Can I say that at this point there's a, as it were, a situation where it's a chance, it's the best possible chance to ensure that in the exercise of your discretion, ultimately, core participants should not be left with doubts about the work of the inquiry, or at the end of it all with, if only, misgivings about why they had not any representation separately at the closed hearings. And that's against the background where previous reviews and reports have left a bad taste in the mouth of the victims of Omagh, where corners have been cut and hard questions were ducked by other bodies. Finally, sir, can I deal with the practicalities of separate representation for differing core participants? I accept totally that if you're of the mind that special advocates should be appointed or recommended for appointment, that the question as to how many or in what shape they should take will have to be considered. But again, I want to say this with sensitivity. The core participants of bereaved families and survivors have been and will always remain united in grief. But we all have to acknowledge that there are differences which have emerged over the past number of years. And those differences have evolved as to emphasis, priorities and concerns regarding certain matters. And you will know, sir, from the various hearings which have already taken place that the core participants we represent have a very distinctive view in the issue concerning the involvement of state authorities in the Republic of Ireland. And you will have heard in my opening statement that we encourage the inquiry to have particular emphasis on the terms of reference at paragraph 2I. And there are, as I say, various emphases which are shared by various groups. And for those reasons, it's our submission that our group should have a special advocate separate from others. No one group has a monopoly on the appointment of any particular special advocate. That would be, in our view, discriminatory. We're happy to liaise to prevent duplication of effort. We accept that imaginative practical solutions can be reached so that, for instance, we could provide summaries of open material as part of the instructions to special advocates, or indeed draw their express attention to full documents. But of course that's within the context of speculating on how much closed material there is likely to be. But I think the bottom line is that we as core participants are requesting that we are not necessarily tied with a special advocate of someone else's choice. And I think that Mr. Southey acknowledged that in the course of his submission, that The answer to that question is the appointment of more than one. Those, sir, are the concerns which we wish to place with you, and we wish you well in drawing together all the various strands which will go to your decision as to where fairness leads you on the question of special advocates. Thank you very much.
Mr. Kane, I think that what you've said to me today is largely directed towards the question of discretion. In terms of whether I have a power, I think you adopt what Mr. Southey has to say.
I do, yes.
There's just one question I'd like your help with, if I may, and it's related to something I canvassed with Mr. Southey, and I think it would be helpful to try and get to the bottom of it. In paragraph 11 of your submissions, you explain that you would see the authority for requesting appointment to lie in section 17 of the Act, and you give some examples of where special advocates have been appointed in other circumstances, one of which is the case of Tariq. Now, as I would understand Tariq, there was power within the Employment Tribunal Rules of Procedure to order that there should be a closed hearing. And then the Employment Tribunal's National Security Rules of Procedure, which were then in force, specifically gave power to the Attorney General to appoint a special advocate when a closed hearing had been fixed. So, specific power to order closed hearings and specific power to appoint a special advocate, all in the context of adversarial proceedings. So, in the case of Tariq, we have an example of proceedings in an adversarial context which provide for both closed hearings and the express appointment of a special advocate. And by way of comparison, in the Inquiry Act proceedings, we have an example of inquisitorial process providing for closed hearings but making no express provision for the appointment of special advocate. And I rather suspect the Secretary of State might say that that's an example of a comparison between one set of provisions governing closed procedures and another set which demonstrates the absence of a power to appoint in the second set. So why do you say that Tariq, in fact, does the opposite and vouches the presence of a power?
Yes, I understand that, sir. I suppose the bottom line is, and that's why we have focused on the discretion which you have, you're not tied by a decision in an adversarial situation. It's an example. All those examples which are given, we relied on one or two there. Mr. Southey relied on a lot more. What essentially we are saying is you, sir, can draw from those decisions what you feel is fair in the present context. None of them are prescriptive. Tariq is not prescriptive. None of them are prescriptive. If they were, then we'd be simply getting up and say, well, sir, you're bound by such and such a case. All we are saying, and I think after all was said and done with Mr. Southey, they're examples from which you can distill certain features which help you to reach a decision to allow special advocates because of the power which you have to exercise fairness.
All right. Thank you. Should we adjourn briefly again?
So yes, just for a few moments, following which we'll hear from Mr. McAleer, who will address you on behalf of the bereaved families and survivors represented by Campbell and Hawley solicitors, Logan and Corrie solicitors, and Roach McBride solicitors.
Thank you. Mr. McAleer, good afternoon.
My name is Fintan McAleer. I appear along with Mr. McGuckin, led by Mr. Toll. And as you're aware, sir, we are instructed on behalf of the co-participants represented by Logan and Corrie solicitors, Roach and McBride solicitors, and Campbell and Hawley solicitors. Can I say, sir, that we are grateful and indebted to Mr. Southey and the Foxhall team for their detailed and comprehensive submissions. and we wish to adopt those on behalf of the core participants for whom we appear. Given the change in the running order this morning, we've also had the benefit of submissions by Mr. Keane, and I endorse those fully in respect of our core participants, in respect of what he has said, for fairness, Your Worship. Or I beg your pardon, Chairman. Unless you, sir, have any questions for me, those are the limit of the submissions I intend to make.
There's a couple of things I wanted to ask you about that I'd be grateful for your help with.
Yes.
And it really arises from what you set out in paragraphs 6 and 7 of your written submissions. And it's really just a question of what you want me to take from these submissions. Because you tell me in paragraph 6 that the deep mistrust and suspicion of the state that exists in this country will never be fully allayed unless it's confirmed that every single document and piece of information is placed into the open. And in paragraph 7, you say that whilst others may concede or accept that closed procedures are necessary, that's not the view of your core participants. Now, I really just need to understand what you want me to take from that. Why do you tell me that every single document and piece of information needs to be placed into the open?
Can I say, Chairman, we respect the powers and the processes of the inquiry. The effort behind that paragraph, or certainly the intention behind that paragraph, was to reflect the effective scepticism faced and experienced by the core participants because of the series of revelations over the years since the bomb, which has served to undermine their trust in the state. Now, we fully accept that the obligations under Article 2 do not require full core participant or public access to all parts of inquiry proceedings. We're simply trying to convey, as Mr. Keane did a few moments ago, the primary view, or perhaps aspiration, of the core participants we represent is that this inquiry should be in public in everything that it does. We accept, as I say, there is a limitation on that, and that paragraph is an attempt to address that so that you, sir, are aware of what our instructions are from the core participants we represent.
Well, you presumably accept that I must conduct the inquiry according to the provisions of the law.
Absolutely, sir.
And just to take an example, if there was, for example, intercept material to be led, is it not clear that the law doesn't permit that type of evidence to be led in open sessions in an inquiry?
I agree. The APT is clear in that.
And it must be part of your function to explain the legal rules that apply to the core participants, mustn't it?
I agree, my Lord.
So what am I to make then of the proposition that every single document, piece of information has to be placed into the open?
Again, I don't want the perhaps clumsy expression to take away in either our faith in the team appointed or in the processes which this inquiry must adopt. The intention behind those paragraphs, as I say, my Lord, is to try and address the concerns expressed by our core participants that things will never be made known to them which should be made known to them. The corollary of that, or the potential assistance that a special advocate would provide, is that there would be reassurance given to the core participants that there is someone present at those hearings specifically tasked with protecting their interests.
All right. Well, you tell me two other things which I'd like to ask you about. You tell me that the power to appoint special advocates is obvious from the case of Roberts, and you tell me that in closed hearings, it's necessary that there should be every possible layer of protection for the core participants' rights, and that obviously includes the use of special advocates. Now, I canvassed the case of Roberts with Mr. Suddy yesterday, and maybe it's clear that what you say is obvious about Roberts may not be quite so obvious to others. Is there anything further that you want to say about Roberts to help me to understand why it's obvious that the power to appoint special advocates is evident there?
Can I say, sir, that I accept your comments, and it's effectively an overly ambitious expression of the submission we intended to make, and I regret that the document doesn't say a power could be read across from Roberts as opposed to being expressed in the terms that it is. Effectively, we are relying there on the judgment from Lord Wolfe, Lord Chief Justice at the time. I think it's paragraph 83 at page 282 of the bundle, where he identifies that a power expressed or implied can be made or exists to appoint a special advocate. The issue we're trying to address is that if there is a principle, as I'm very ably assisted by Mr. Southey in his submissions, that where there is a procedure where there will be restricted access and restricted hearings in respect of certain material, and there is a right or a duty for fairness, then if there is another measure that may assist those persons who are excluded from those hearings, then when one looks at the test of fairness, all measures should be considered. I put no further than that, sir.
All right, thank you very much, Mr. McAleer.
Thank you, sir.
Mr. Greenie.
So again, we would invite you to rise for a few moments, following which we will invite Mr. Mansfield, instructed by Elevate Law, to address you on behalf of the Rush family.
Thank you. Good afternoon, Mr Mansfield.
Good afternoon.
Now, Mr Mansfield, I know you injured your ankle. Would you be more
Well,
comfortable
it was my
sitting
knee,
down?
but don't worry.
Would you be more comfortable sitting down?
I can stand for the moment. If I suddenly disappear, perhaps you'll...
Well, please, whatever feels
Yeah,
more comfortable.
it's better to stand, I think, if I may, because as you will anticipate from our written submissions, they're very short indeed. I appear on behalf of Lawrence Rush and his family, and we've made it very clear that we are not, and I'll put it carefully in terms that you've already been describing, namely, we're not asking you to ask the law officer to appoint a special advocate for the purposes of the Rush family, although they are clearly in the history of this matter in the forefront of asking the questions you're going to ask. But I'm not pursuing that, and therefore I think it's probably diplomatic, if not otherwise, for me to say little on the question of the power, unless you want me to, or the exercise of a discretion in relation to that, because we're not asking for that. Implicitly, obviously, there are various matters that can be inferred from our not asking. But there is one caveat to that, if I may just develop it, because listening carefully to arguments that have already been put before you, I think the Rush family are concerned in relation to if you consider you do have the power and you do exercise the discretion to appoint special advocates. The problem the Rush family would like you to consider alongside, I'm sure you will, is the question of delay, because you've had the situation described, in fact, this morning, but also before today, and Mr. Greene has already indicated we would say it's inevitable there's going to be delay if there are going to be special advocates, because you can see that there can either be the original special advocates that may be re-employed. On the other hand, if they're going to be tainted, it can't be them. There may be new ones. And in the light of Mr. Kane's submission, there may be a multiplicity of them, because certain families will feel they need separate special advocates to the ones representing other families. So that in itself, that is the number of advocates that may be involved in the process. But then there's the premises. We've heard about predictions of when things will become available in the past. Again, there is a commitment, but again, it's not entirely clear whether it will be available. So you have not only the number and identity, but also the premises. But of course, there's the actual operation is also subject to delay, because I want to posit the situation, which I hope is a practical one, whereby, let us suppose there's bound to be more than one special advocate, they are going to have to read the material. Now, in this case, the terms of reference are important because they're very focused, they're very clear what they concern, that is a central issue of preventability. And the terms of reference are, I'm not going to read them out because you're very clear about what they are, but in each case, in each of the terms as spelt out, it will be necessary for the special advocate to know about all the other material as well, because he's not going to be able to, or she is not going to be able to make an assessment about an issue of disclosure unless they know what's already there and what isn't there. So the process, even once they're appointed, even when they've found premises, there's going to be the risk of more delay while these matters are read up, as it were. And there is in some of the authorities the suggestion that the special advocate turns up to the open hearings and listens to, well, in adversarial, how the case is put, but in this one, it would be the context in which materials are being not disclosed or disclosed, because the very first term of reference deals with a risk assessment. So if there's closed material in relation to that, you have to know what the risk assessments were saying.
So this is the issue I was touching on with Mr. Southey yesterday, as to whether the special advocates would have to have access to all of the open material.
My answer would be yes. And there would be it's far be it from me to say what a special advocate should do, but I think it would be desirable for a special advocate to have traversed most of the open material. There may be sections that perhaps don't pertain, but in this particular case, it being closely defined and a series of interrelated issues, it would be very difficult to select some and not the rest. So that whole layer of, can I put it as an investigation in a sense, and representation, inevitably is going to cause, we say, well, dare I say it, for the benefits that might accrue, a disproportionate amount of time is going to be spent by counsel having to, as it were, go through all of that procedure. And this leads into, and I assure you now, I'm going to finish before lunch, but well before lunch, but it leads into a correlated issue, and that is, and it is, I think, part of Mr. Kane's written submissions, that his primary contention, and we would agree with this, is that as much material as possible should be held in open for obvious reasons. I don't need to elaborate. You've already mentioned them yourself.
That's in effect what Section 19 tells us, isn't it?
It's because of public confidence and all the other explanations that are being put before you. And we would say this gives rise to, and in a sense I'm trespassing on things that might come later, but it may be important to raise them now. Because if you're going to, we're dealing with a situation which is over 25 years ago, and leaving aside the materials that arise out of intercepts, I leave that as a category, but there's a much bigger category than intercepts. It's all the other materials where government departments, Ministry of Defence and so on may be saying they're having a restriction notice preparatory to a restriction order, and there may be a need for argument in that area, that we say, given the history here, namely this is unlike Litvinenko, and a case which I've been involved in and I still am, which I want to mention in 1 second, the Novichok inquiry. They were dealing with very serious current risks, and so it was fairly obvious to all that it would be virtually impossible for those conducting those, particularly the Novichok one, since it concerned threats to security from Russia, that it was unlikely that much of that could be in public. Whereas in this case, as you go through the terms of reference, one hopes that the mantra that is often put up, namely, it's not in the interest of national security, you will apply a framework, a template of rigorous scrutiny as to whether that really is the case after all these years, that assessments that were made nearly 30 years ago have a risk to national security now. I don't need to go further because I think the point makes itself. Now the way, if I may just deal with this as an add-on to that, the questions that would arise in relation to any documents can be dealt with in this case, we say, not only by Mr. Greenie himself, I've made that clear already, but there is a procedure which perhaps I'm sure you will have read, but it might like to bear in mind. And it's in the Afghan case, which you have already been directed to, but not the section that I want to just touch upon. And it's item 48 in the index, and that's the Afghan inquiry. And then it's paragraph 158. Now, the point about the paragraph at 158 is that the law officer who would be now responsible was making an argument for a particular procedure. And I think the importance of that, sorry, I'm just looking if I left my glasses there. Yeah, I have. Sorry, thanks very much. The importance of this is that what happened in the Novichok case, where we're still awaiting the report, but it's important to recognize that what actually happened as a matter of practice is one of the reasons, not the only one, that we are not asking you to ask, well, the Attorney General now, but at the time representing certain parties on that inquiry, we're not asking is that a procedure was adopted in Novichok. We didn't apply for special advocates. In fact, there was no argument about it at all, although in fact the team of lawyers I was working with, one of whom had been on Litvinenko, so he's fully aware of the possibilities. But the paragraph 158 onwards, Mr. Hermer suggested a solution to the admitted problem of the need to protect national security material was the proposal of holding hybrid hearings with military witnesses. Most of them were concerned with that in the Afghanistan one, with military witnesses giving evidence partly in open and partly in closed. And then the arguments are set out on that page, 1293, an analysis. Now, I again, to save time, I don't read them all out, but you will see the arguments in favor of a hybrid hearing do apply to this particular inquiry, the one that you're handling yourself, because we say not all the witnesses are going to be in the same category. And what happened in Novichok was this, that Lord Justice Hughes, who was chairing, where the issue was exactly the same as this one, preventability, developed, I think it wasn't subject to discussion, it just happened, rather like Topsy, that once I started asking questions, for example, police officers in charge of the scene in Salisbury, one of the two scenes, the other one was Amesbury. What was allowed in our case was that since I was dealing with preventability, it was agreed that I could ask the questions in public myself on behalf of the family as to what questions had to be answered. Obviously, I wouldn't necessarily get an answer each time, and the chair would say, I think Mr. Mansfield, no, or yes, or whatever. So it was done very much on an informal basis, but it worked in the sense that occasionally a witness would stop, the chair would say, well, I think you can answer that one. Or there would be a gist, I'd be given a gist of what was, the material that I couldn't see. But it progressed speedily. It didn't hold the inquiry up. No one complained about it. And the same applied to the intelligence community. I was allowed to do the same, ask the questions, didn't always get the answers, but occasionally you got a bit more than you bargained for, which was a bonus. Now, it's akin to a hybrid hearing of the kind that is set out here, although it was rejected for reasons that it would be really impossible to operate in the Afghanistan case. But we say in this case, that system could be operated as a kind of backup to the argument. I don't predispose what your decision will be about whether you can appoint as a matter of power and whether you're going to as a matter of discretion in particular cases. So I'm not trying to preempt that. I'm just suggesting that in terms of the case I'm putting, namely, I'm not asking for a special advocate, and I'm not saying provided I can ask these questions either, but this is a potential further down the line where we would want to be arguing, as I did in Novichok, because you might get a category of document that I'm told about. I'm not told what they are, just a category. And then I could make submissions on the category. And even if it was going to save time, I would tell Mr. Greeny, for example, here, what the concerns would be, that I can't air them publicly, but he could deal with it in a closed session. So there are practical ways, we say, within the law that will provide the family I represent with the necessary reassurance that they already have from your presence and Mr. Greeny's presence. That is all I would want to say at this stage.
Well, thank you, Mr. Mansfield. That's helpful, and I'll give close consideration to your explanation about the hybrid system, and I'll read what was said in the Afghan case about that.
Yes, certainly.
Thank you.
So this would seem to be an appropriate point to break for lunch. And could we return at about 1:45, please?
Thank you. Greenie.
Good afternoon. So we'll hear now the submissions of Mr. McKay on behalf of the Police Ombudsman for Northern Ireland.
Well, good afternoon, Mr. McKay.
Good afternoon, sir. So you have the submissions of the Police Ombudsman for Northern Ireland on the issue of the appointment of special advocates in public inquiries, dated 15th April 2025, at pages 57 to 75 of the bundle of submissions. The Police Ombudsman, as you know, is neutral on the question of whether a special advocate or advocate should be appointed. Although it is submitted, it is open to you to appoint if you consider it necessary to do so. The written submissions and these additional short oral submissions are designed to assist the inquiry in identifying the relevant legal principles and contribute to your resolution of the issues as set out in the series of questions posed by the inquiry legal team. Can I emphasise, if you do not think they assist you, please, of course, disregard them. The inquiry has invited submissions on three broad areas. First, the existence or not of a power by an inquiry established under the 2005 Act to appoint a special advocate. Second, if there is a power to do so, the factors relevant to the exercise of that power. And third, the practicalities of doing so. The following submissions augment and clarify, where necessary, the Police Ombudsman's written submissions. As to whether there is a power, it is the common position of all parties that there is no express legislative provision in the 2005 Act providing for the appointment of a special advocate, and there is specific statutory provision for the appointment of special advocates in certain types of closed proceedings. Of the many examples provided, none serve a like purpose to the 2005 Act, which, as the explanatory note to the legislation makes clear, is to, quote, provide a comprehensive framework for inquiries set up by ministers to look into matters of public concern, unquote. Like its predecessor, the Tribunals of Inquiry Evidence Act 1921, there is a presumption in favour of public access. The Select Committee report on government by inquiry, published in January 2005, which was one of the catalysts for the introduction of the 2005 Act, included at paragraph 86, under the heading Public versus Private, the following summary of some of the evidence that it had heard. Quote, Lord Salmon's observation on public versus private evidence gathering was succinct. Secrecy increases the quantity of the evidence, but it debases its quality. The Council on Tribunals considered that, in principle, it seems right that an inquiry into a matter of public concern should itself be conducted in public, unless there is a strong public interest in the inquiry or part of it being held in private for reasons such as national security. Aside from any other consideration, public hearings go a long way towards reassuring the public that the subject matter of the inquiry has been fully investigated and that there has been no cover-up, end quote.
I'm just a little behind you, I think, Mr. McKay. Are we looking at the effective inquiries consultation paper?
So we might be looking at the final report after the consultation.
The final report?
That's the one dated January 2005. Or the government's response, it may be titled. I don't have it in electronic form in front of me, unfortunately. I understood it was the same one that you may have mentioned yesterday, but there were a series of reports in response to consultation. But I can get the reference, sir, after you've heard my submissions.
Yes, that's fine.
The stated aim of the 2005 Act and the way Section 19 is drafted in my submission imply the powers of the inquiry chairman to make a restriction order or the minister to issue a restriction notice are to be used only after the most exhaustive consideration of the applicable criteria, and therefore likely sparingly. The provision in Section 19 is far more onerous than Section 2 of the 1921 Act, which enabled an inquiry established under that legislation to restrict public access in the public interest only. The avowed aim, of course, of this inquiry has been that as much of the evidence will be heard in public as possible. Making express provision for the appointment of a special advocate in the 2005 Act would be, in my submission, to acknowledge that the use of restriction orders or notices would be sufficiently prevalent such that provision was a necessary prerequisite. This would be inconsistent with its legislative purpose and could undermine public confidence. There is a distinction between the legislation referred to in Council to the inquiry's note dated 17th June 2025 and a statute that has the investigation of matters of public concern at its heart. Lord Bingham, at paragraph 21 of Crown and H, the page reference, I don't need you to look it up, sir, unless you want to, but it's a case I know you're very familiar with after the submissions you've heard, but the page reference is 215 of the Bundle of Authorities. But in that case, Lord Bingham recognised this distinction between proceedings brought under several of the statutes referred to by Council to the inquiry that at least existed at the time H was decided, and that which his lordship described as, quote, the position of a defendant in an ordinary trial, unquote. If there is commonality, this is to be found to a limited extent, not in the raft of statutes that expressly provide for the appointment of special advocates, but in the criminal trial and an inquiry under the 2005 Act. Both proceed, in my submission, on a presumption of open justice and to get to the truth, even if they do so in different ways through adversarial and inquisitorial modalities. For these reasons, it is submitted that no significance should be given to the fact that the 2005 Act is silent on the use of special advocates as a basis to infer one or more could not be appointed. Indeed, the omission of express provision to do so is in harmony with the expectation that a restriction order or notice will be used as the exception and not the rule. The Police Ombudsman in her written submission submitted that your power to appoint, and it is submitted you have such a power if it becomes necessary to use it, derives from Section 17(1) and 3 of the 2005 Act. It's very familiar to us all, but it's worth repeating. The procedure and conduct of any inquiry are to be such as the chairman of the inquiry may direct. And 3, in making any decision as to the procedure or conduct of an inquiry, the chairman must act with fairness and with regard also to the need to avoid any unnecessary cost, end quote. The appointment of a special advocate is procedural in nature. Chahal and the United Kingdom at 131, which has not in fact made its way into the authorities bundle but is cited by a number of the other cases, including Roberts, at page 278 of the bundle, makes this plain. Quote, this is the court in Chahal. The court recognises that the use of confidential material may be unavoidable when national security is at stake. This does not mean, however, that the national authorities can be free from effective control by the domestic courts whenever they choose to assert that national security and terrorism are involved. That there are techniques which can be employed which both accommodate legitimate security concerns about the nature and sources of intelligence information and yet accord the individual a substantial measure of procedural justice, end quote. You are therefore, sir, the master of your own procedure, subject only to a requirement to act compatibly with the Human Rights Act 1998 and the usual well-established public law standards. Section 17 in my submission provides the margin of appreciation within which you can exercise your discretion in a human rights compliant way. The Convention imposes on you, amongst other things, the obligation to ensure a substantial measure of procedural justice is accorded to core participants where they are excluded from the proceedings. The appointment of a special advocate or...
What's the authority for that, Mr McKay?
I beg your pardon, sir?
You say the Convention imposes an obligation to ensure a substantial measure of procedural justice is accorded to core participants. Well, what's the authority for that?
Perhaps the qualification would be the Convention jurisprudence and the authorities Chahal as a principle. Chahal is very different in circumstances, but I say that you can export that principle where a right is being restricted of access to a court. The principle is that providing you accord some procedural fairness to the individuals affected by that derogation.
But I'm not a court.
No, you're not, but you are a public authority for the purposes of the Human Rights Act, sir.
But what's necessary for procedural justice in a court is not necessarily the same as what's necessary for procedural justice before an inquiry.
I entirely agree. But the principle remains the same, that the justice must be afforded to those affected. I wouldn't have thought that's a controversial proposition based on the submissions that you have heard. It would be an extraordinary position if...
Justice must be afforded to those affected.
Yes.
Who are those affected?
Well, those affected by the derogations.
It's a very broad concept to say that justice must be afforded. Justice is something that's usually achieved in the context of a contested litigation. What I'm required to do is to provide an effective form of investigation in which the next of kin are able to participate to the extent necessary in order to safeguard their legitimate interests.
So yes.
I'm not sure that's just exactly the same as saying that...
It isn't, sir. In a sense, it's almost a consequence of the protection of their legitimate interests in my submission. And one way those legitimate interests are protected is to accord them procedural justice or fairness. Fairness is probably a more neutral term because it adopts the language, of course, of the Act.
Yes.
The appointment of a special advocate or advocates is one measure available to you, but it is only one. It may be novel, as Mr. Greenie Casey observed yesterday, but as Lord Bingham noted in Crown and H at 22, and again, I think this is a broad enough principle to export across to the current situation. Novelty itself is not an objection. So the Police Ombudsman also explored as an alternative position whether Section 18 of the 2005 Act could, if necessary, be read down in accordance with Section 3 of the Human Rights Act to permit the appointment of a special advocate. This was in response to the question posed by the inquiry legal team exploring possible legal bases for appointment and was designed to assist. Counsel to the inquiry has questioned whether this submission is correct. In light of the role the Police Ombudsman is attempting to play in these proceedings, and in particular on this issue, and her position on the scope of Section 17, it is not a submission I propose to pursue, as it strikes me that it is now, if it ever was, unlikely to assist you.
All right, thank you.
The related question arises, couched with appropriate care by your legal team, that if such power existed to appoint and you exercised it in favour of the appointment, understanding the process associated with that you discussed, of course, with other advocates so far who've made submissions, could there be disclosure of intercept product to them if, hypothetically, this was required?
If you're moving away from the power to look at the 2016 Act, there's a couple of things I'd just like your help with.
Of course, sir.
Before we do. Your overarching submission of course, is that there is power within the 2005 Act and the rules to appoint special advocates. And you draw my attention to section 17 of the Act. I understand that. At paragraph 12, though, you say that the inquisitorial nature of the inquiry is not relevant to the question of whether a power exists. And I just wondered why that was, because is it not the case that every other statutory scheme which provides for the appointment of a special advocate is a scheme which operates under adversarial proceedings? I can't think of
Is this
one.
paragraph 12 of the written submission, sir?
In paragraph 12, you tell us that section 17 gives the power in your submissions. And then at paragraph 16, you say that it's not relevant to the question of whether a power exists, that the inquiry operates on an inquisitorial basis. And what I was... Am I misreading you?
So I'm just trying to get the references correct. Paragraph 12 of my submissions are in response to the question posed by the inquiry.
You say the power could arise from section 17.
Yes, that's in response to the third question proposed by the inquiry team, given the absence of an express power.
Yeah. So
yes.
is there a power? Is that
yes.
what it comes to? Yes. And then following that through, you say that it's not relevant to the question of whether a power exists, that the process is inquisitorial.
Yeah, I don't think it's relevant to whether the existence of a power exists. I do think it's relevant to how you exercise the power.
Well, I follow what you say, but what I'm wondering about is why it's not relevant to the question of power, because unless I'm wrong, it seems to me that every other statutory scheme which provides for the appointment of a special advocate is a scheme which operates within adversarial proceedings. Now, is that right, do you think?
I think that happens to be the pattern of the way that the law has evolved. And I think it's a feature of public inquiries or inquiries under the Act that they're not adversarial, and therefore this issue arises when it has in the various inquiries that have been referred to. And I also think it's why some of those inquiries have reached the conclusion that the power exists. But I don't think one could identify as a principle that the power only can arise in adversarial proceedings.
Well, it occurred to me that perhaps what was in Parliament's mind was that you need a special advocate in an adversarial proceedings because of the particular function of the judge, which is just to adjudicate.
Yes.
Whereas in an inquisitorial proceedings, the function is to investigate. So Parliament may have taken the view that it's not necessary to have a special advocate in inquisitorial systems.
That certainly may be the position. So the difficulty one has is drawing it as a firm conclusion based on the various decisions that have been reached and the way the legislation is drafted in different circumstances. A lot of the legislation, of course, predisposes that closed sessions are an inevitability. And of course, they come from different perspectives. And I think the reason why the provision in Section 17 is couched in the broad terms that it is because there are certain circumstances, even in inquisitorial proceedings, where the need might arise.
You also...
It's not a foregone conclusion.
Sorry. You also seem to suggest something, I think, which is additional to the route suggested by the families as to how a special advocate might be available. And what I think you suggest is that under Rule 6, a special advocate could be appointed as the recognised legal representative for the purposes of closed hearings only, or alternatively, that a special advocate could be appointed as part of the legal team in terms of Rule 8.
Yes.
Now, that's a route to appointment of special advocate, you would say?
Well, so can I say this, that the approach that's been taken by the legal team in the exploration of these issues is a Q&A approach, and it's very helpful and very constructive. And one of the things that certainly the Police Ombudsman took from that is that there should be an effort to consider all of the options. But what she isn't doing in a partisan way is making representations or submissions to you that this is definitely a route, or it's one that commends itself to you. But in a sense, there are considerations that need to be given.
Well, I understand that. That's why I'm asking you about it, because if this is a route, then I'll need to give consideration to it. Now, yeah. I realise you're not saying to me this is the route that you should necessarily follow.
Yes.
But if it's a route that's conceivably available, then I should think about it.
Yes.
So, Rule 6, you say, could allow a special advocate to be appointed as the recognised legal representative for the purpose of the closed hearing. But I struggle with that because it seems to me to be inconsistent with the fact that special advocates can only be appointed by the relevant law officer, and that there's no ordinary professional relationship between a litigant and a special advocate. So there are no circumstances, it seems to me, in which a litigant or a court participant could appoint a special advocate.
There isn't. That's correct. That's a correct statement of the law, so yes.
Well, you seem to say that you could under Rule 6 for limited purpose.
If you don't find that submission helpful, I abandon it, sir. So it was an exploration of whether or not there was an ability to read the rules in such a way that would facilitate the appointment, if that was a conclusion that you reached.
So you're not pressing that?
I'm not pressing. In fact, sir, can I say this? I'm not pressing any of the points that the Ombudsman makes. They are all purely designed to try and assist. We're in a very unusual position.
Well, we are, and I'm only asking about them so that I'm sure that I can be clear as to whether there is a route that may be additional to the one suggested by the family or not. But if you maybe accept that that's not a particularly powerful suggestion, we could just move on.
Yes, and I think the primary position of the Ombudsman has always been that Section 17(1) provides the power. The mechanics of that were explored. If you don't find them attractive or helpful, please disregard them.
You want to look at the 2016 Act?
I do, sir, because I hope that this is one area where I can assist you.
Good.
More constructively than I have a sense I have so far. The position of the Police Ombudsman is this, that if a special advocate is in principle capable of being appointed, we agree with the analysis provided by counsel to the inquiry that paragraph 22 of Schedule 3 of the Investigatory Powers Act 2016 does not empower you as chairman to make a disclosure to a special advocate. That would contravene Section 56 of the Act. Section 56 makes provision, of course, for the exclusion of material derived from interception-related conduct subject to Schedule 3. However, sir, as I've identified in the submissions, I think there is a potential route to enable such a disclosure to be made, albeit not by you, but by your legal advisor. Assuming, hypothetically, the existence of intercept arises in this inquiry and you order disclosure of it to your legal advisors in accordance with paragraph 22(1) of Schedule 3, consideration could be given as to whether a disclosure by the solicitor to the inquiry to a special advocate would be permissible. Can I invite you, sir, to turn to page 74 of the bundle of authorities? This is Section 57 of the 2016 Act.
I'll just use my own printed copies if that's convenient.
I beg your pardon, sir?
I'll just use my own printed.
Of course, sir. Yes, absolutely, yes.
So Section 57.
Section 57 I'll read in, for the record, the relevant parts of that provision. Section 57, duty not to make unauthorised disclosures. 57.1, a person to whom this section applies must not make an unauthorised disclosure to another person. Subsection 2, a person makes an unauthorised disclosure for the purposes of this section if A, the person discloses any of the matters within subsection 4 in relation to 1, a warrant under Chapter 1 of this part, that's Part 1 of the IPA, sorry, Part 2 of the IPA, or a warrant under Chapter 1 of Part 1 of the Regulation of Investigatory Powers Act 2000, and the disclosure is not an accepted disclosure. Subsection 3, this section applies to the following persons, subparagraph F, any person to whom any of the matters within subsection 4 have been disclosed in relation to a warrant mentioned in subsection 2A. Now, just pausing there, so the warrants mentioned in 2A do not include a warrant under the 1985 Interception of Communications Act. But can I point this out in the hope that it assists? There is a deeming provision in the Regulation of Investigatory Powers Act at 82.4, which deems, in certain circumstances, a warrant under the 1985 Act to be an interception warrant for the purposes of the 2000 Act. And that would require examination by you or your team in due course.
Where's the deeming provision?
It's 82.4 of RIPA 2000.
I wonder if that then ties in with something that I was uncertain about. You tell us that section 56 4 D2 applies to the inquiry.
That's the provision in relation to conduct under the 1985 Act.
Yes.
Yes.
So what we see in section 56 is that a reference in subsection 1 of section 56, which is the prohibiting provision, also applies to the making of an application for a warrant or the issue of a warrant under the Interception of Communications Act 1985.
Yes, sir.
And because of the timing of the material we're dealing with, we're likely to be dealing with material covered by the 85 Act rather than later legislation.
Or potentially both. Yes. There's, depending on the investigative elements that you'll no doubt examine, it is theoretically possible that we might be dealing with the period after the 2nd of October 2000 when the Regulation of Investigatory Powers Act repealed the 1985 Act and commenced to have effect.
Why does section 57.4b not apply?
57.
56 or 4b.
It could apply, sir. I hope I haven't suggested that it. I hope my submission doesn't just suggest that the.
Well, you said it doesn't. In paragraph 25, you've said the conduct set out in section 56.4b does not arise.
Oh, sorry, yes. That's because the offence in the 1985 Act was different to the offence in the subsequent legislation. I think the offence in the 1985 Act was the interception, unlawful interception without a warrant. So there would be no question here of interception taking place without a warrant.
Well, it was conduct that would be unlawful in the absence of a warrant.
Yes.
Is that not the same as what we have in section 57, section 56 2A.
Well, section 56.2a deals with the concept of lawful authority, which didn't exist in the 1985 Act, and which makes provision for a number of forms of lawful authority, but one of which does include a warrant that's been properly issued under the Act.
Well, it tells us that what interception-related conduct is, and
Yes.
it's a conduct that is, or in the absence of lawful authority, would be an offence.
Yes.
And that's what Section 1 of the 1985 Act said as well, is it not?
Could you give me a moment, sir, to look at the 85 Act? So one of the disadvantages of working from electronic copies is that you don't always have it readily to hand. I apologise. Yes, so the offence under Section 1 of the 1985 Act was that a person who intentionally intercepts a communication in the course of its transmission by post or by means of a public telecommunication system shall be guilty of an offence. And a person shall not be guilty of an offence under that section if it was interception in accordance with a warrant. Yes.
So that means that intercept would be unlawful unless it was covered by a warrant.
Correct.
Is that not the same as 56 2A?
Yes, but it doesn't arise in this case, is the point that I think I'm trying to make. There's no question that any interception which hypothetically occurred, there's no question that it happened unlawfully.
Sorry?
There's no question that it would have happened unlawfully.
What difference does that make? Would disclosure, if we're talking about...
Yes, so the prohibition on disclosure, we're not concerned about any issue that arises where you can disclose because the offence has been committed. So the way that the offence was structured was
no, but the Act prohibits disclosure of intercept-related conduct,
yes,
regardless of whether it was done lawfully or unlawfully, unless we're talking about prosecution.
Yes,
of an offence.
yes, quite.
Yes.
Yes.
So you're going to explain to me why it is, I think, that the solicitor to the inquiry can make an accepted disclosure.
I'm certainly going to do that if it assists, so yes. May I just try and find my place on the original document? Yes, so the solicitor in such circumstances is a person to whom Section 57(3)(f) of the 2016 Act might apply. Of course, that's not something I or any of the other parties would know. And any disclosure by him to a special advocate could be authorised. Would be unauthorised unless it was an accepted disclosure. That's the effect of Section 57.
Okay.
So I'd invite you to then go to page 77 of the bundle or Section 58 of the Act.
Yes.
Section 58 is entitled Section 57 : meaning of accepted disclosure in parenthesis. Section 58(1), for the purposes of Section 57, a disclosure made in relation to a warrant is an accepted disclosure if it falls within any of the heads set out in subsection C, subparagraph C, subsection 5, legal advisors. And then, sir, if you drop down to subsection 5, head 3 is a disclosure made by a legal advisor, 1, in contemplation of or in connection with any legal proceedings.
And you would say that disclosure by the solicitor to a special advocate would be in connection with legal proceedings?
It's a very broad definition that's given to legal proceedings, sir. Any legal proceedings.
Well, the difficulty with that is that Section 56 in subsection 1 appears to distinguish between legal proceedings and Inquiry Act proceedings. It says no evidence may be adduced, questions asked, etc., in connection with any legal proceedings or Inquiry Act proceedings.
Yes.
So they seem to be different things. And then when we get to Section 58, subsection 9, we find it tells us nothing in this section affects the operation of Section 56.
Yes.
Which, amongst other things, prohibits the making of certain disclosures for the purposes of in connection with legal proceedings.
Yes.
So there's no, if you just read the words of the section, there's no accepted disclosure in relation to what the legislation calls Inquiries Act proceedings.
Well, so yeah, that if your view is that legal proceedings, any legal proceedings, is qualifying legal proceedings with Inquiry Act proceedings, then that's a point that I would concede. But the terminology is...
It's not my view. I'm just looking at the words and trying to make sure I'm not missing something. So there's no reference to what you've just described as any legal proceedings, other than what we see in Section 56(1), where it tells us in connection with any legal proceedings or Inquiry Act proceedings.
Yes.
And that would seem to be a disjunctive description.
Yes, I would have to concede that then in those circumstances. So if you were of the view that precluded Inquiry Act proceedings, then that would be the end of the potential route to disclosure to a special advocate.
All right.
Of course, I think that would be the extent of my submission, sir.
The deeming provision I'm just trying to find that you mentioned, did you say it was in the 2000 Ripple Act?
Yes, sir.
I've got section 82, but subsection 4 seems to have been amended or deleted. Seems to have been...
Seems to us to have been repealed by the Act of 2016.
Yes, the IPA, yes.
So there's no deeming provision then?
Not anymore. But I was attempting to explain why a warrant under the 1985 Act did not appear in that part of the IPA. But of course, if it has been repealed, I'm looking at the original Act. I apologise for that, sir. If it has been repealed, then of course that point falls away as well. And I am singularly failing in my duty to be of assistance to you.
All right, never mind. So that probably takes us to the end of that discussion about...
It takes us to the end of that discussion, so yes.
All right, thank you. Was there anything else you wanted to mention, Mr. McKay?
Not in relation to route to disclosure to a special advocate in those circumstances, sir. I have some remaining short submissions to make on the exercise of your discretion. Any derogation from open justice should always be the exception and only where strictly necessary. Balancing the effect of derogation through the appointment of a special advocate is and has consistently been held to be exceptional. You need to consider whether you can, to quote Baroness Hale, do justice according to law, not only by arriving at a just result, but arriving at it in a just manner. The appointment of a special advocate is only one measure at your disposal. There are others, some contemplated by the European Court of Human Rights in Carter and Russia, and referred to by you yesterday. Concessions, admissions made by core participants, summaries, gists, or other forms of words. Indeed, even as Mr. Mansfield has canvassed a confidentiality ring, although that has not always found favour with courts and tribunals. Or a hybrid version of the confidentiality ring. No, that's fine. Or indeed even your team agreeing with core participants the questions, concerns or areas that they want to see raised in closed session. I should deal with, and do so with some caution, the issue of content of intercept. It is the submission of the Police Ombudsman that the content of intercept communications is and always has been capable of being disclosed, providing, emphasis on that word, providing it does not offend against the prohibition. And that's the position that's existed since the 2085 Act. And reference is made to Preston. There is some disagreement between the Secretary of State and the Police Ombudsman on that point, but I don't think it's a disagreement of significance. He relies on the speech of Lord Jauncey in Preston, which says, effectively, yes, it can be, but the difficulties are almost insurmountable, and we would agree with that.
Has it not, for practical purposes, been replaced by paragraph 21?
21
of Schedule 3.
Yes, I was about to get to that. So yes, so the things have moved on essentially, and we're now in a position where these things are managed under, as you say, Schedule 3, and before that, sections 17 and 18 of RIPA 2000. And for the avoidance of doubt, the latest code of practice on in the interception communications also emphasises that remains the case. And incidentally, the discussion between Mr. Southey and you yesterday about whether a special advocate could have a role in the Section 18 type situation, it seems to us doesn't arise because of the way that section is drafted. The very purpose of Section 18 is to make sure that the prosecutor, as I think you provisioned yesterday, can discharge his or her responsibilities to disclose relevant material in a way that doesn't offend the prohibition. And there could conceivably be no role for a special advocate in those circumstances.
That's paragraph 21 point, is it?
Yeah.
Yes.
When exercising your discretion, consideration may be given to whether any lesser measures can afford the necessary procedural justice or fairness to the core participants before considering an appointment. It may well be that your own counsel can provide the necessary safeguards in respect of all, many, or some of the issues that need to be aired in closed proceedings, but not necessarily all. That is a decision that you make at an appropriate stage of the inquiry. If an appointment of a special advocate or the appointment of a special advocate is necessary, the appointment can be limited to discrete aspects of the closed proceedings in theory. So we refer to the case of A Chief Constable and another and YK and others, a 2010 All England reports, D59, at page 583 of the bundle of authorities, although it's not the full report in the bundle. In that case, Mr. Swift, KC, as he then was, identified 4 matters which he thought the court should consider before the appointment of a special advocate in a non-statutory case was necessary. Those 4 being the purpose for which the special advocate has been requested, Parenthetically, for example, was it for the purposes of assisting the court on a determination of a PII application, but one could substitute there, in the present context, any procedural issue, including disclosure? Or was it for the purposes of a hearing on a substantive issue? And if so, what is the substantive issue? Secondly, the situation which had arisen in the proceedings before it, which had caused the request to be made. 3, the reasons why the court had concluded that the appointment of a special advocate was necessary, rather than some other step within the court's own powers. And fourthly, the ways in which the court considered that a special advocate would address the procedural difficulty that existed. Adopting those factors or some variation of them would enable a principled approach to be taken to the range of different circumstances where the question of the appointment of a special advocate might arise in the present case. They could also assist you determine whether the particular circumstances require an appointment or multiple appointments of special advocates or none. If you reach the conclusion that a restriction order is necessary and that fairness demands that you put in place measures to accord the necessary procedural justice or fairness to core participants, and it is a fluid concept, sir, not as you referred to yesterday as an inanimate object sitting on a shelf, then the practicalities in whatever form need to be confronted and dealt with. Such limited assistance that the Police Ombudsman can provide is set out in the written submissions filed on her behalf. And the final submission that the Police Ombudsman would make is really just one of emphasis that any derogation or the derogation from open justice, it does not demand of one single solution. There are a range of measures available to you to attempt to redress the balance. I end the submission as a former special advocate myself with the observation that the appointment of a special advocate is not a panacea for many of the reasons set out by Mr. Greenie Casey yesterday morning. And it may be, indeed, is likely to be why Lord Bingham in Crown and H described their use in that case as a course of last and never first resort. So those are the submissions I've made on behalf of the Ombudsman. I don't know if there's anything else arising, and I apologise if at times I've been less helpful than I would have liked to have been.
Thank you, Mr. McKay. You've been very helpful.
So the next advocate to address you will be Ms Grange on behalf of the Secretary of State for Northern Ireland. It is probably more convenient if we take a break of 10 minutes or so now for the stenographer so that we do not have an interruption to Ms Grange's submissions.
Yes, thank you. Ms Grange, good afternoon.
Good afternoon, Mr Chairman.
So, when you're ready.
Yes, thank you. Yes, I appear on behalf of His Majesty's Government in these proceedings. Today I'm leading Mr David Reid of Junior Counsel. My submissions are going to be divided into the two key topics, the question whether there's power to appoint a special advocate, and then whether, assuming there is such a power, you should exercise your discretion in order to request the appointment of special advocates. Our position on these two key questions is that the language of the statutory scheme, the purpose and the context of the legislation, and Parliament's intention as demonstrated in subsequent legislation all strongly suggest that no such power exists. Alternatively, we submit that even if such a power existed, it would not be necessary or appropriate for the Chair to make any such appointment in this inquiry. No inquiry has taken that step to date, even inquiries with a very substantial closed national security element to them. And there is no justification from departing from that approach, we say, in this particular case. We've made detailed submissions in writing. I don't propose to repeat all of those. I'll try and focus on the key points. So turning then to the power to appoint a special advocate. In seeking to persuade you, Mr Chairman, that there is no power to appoint special advocates, it's important to look at three key topics. First, the express language used in the statutory scheme. Secondly, the statutory context as principally revealed by a consideration of the words used in the Act itself. Thirdly, parliamentary intention as evident from changes made to the legislation, including in the national security sphere since the coming into force of the 2005 Act. And then I'm going to briefly address you on why we say that Articles 2 and or 3 of the ECHR and or Section 3 of the Human Rights Act 1998 don't affect the analysis of whether you have the power to request the appointment of special advocates. And I'll briefly address you on the rulings that have been made by other chairmen in this area. On the discretion question, I'm going to be making 8 key points as to why you shouldn't exercise your discretion. So turning now to the express statutory language, it's our submission that when you're exercising your powers under the Act and the rules, you are exercising statutory functions and your powers are limited to those conferred on you expressly or by necessary implication by the statutory scheme. And indeed, the test of necessary implication is a demanding one. You get that from Lord Carswell in the Roberts case at paragraph 131. I think you have your own version of Roberts. But if you'll recall, Lord Carswell at that point said, implication, it's a demanding test. And I don't understand Mr Southey or anyone else to be contending that there's some kind of independent source of common law power which you should use in which to say you have the power to appoint special advocates. It's either got to be in the express language of the Act or by necessary implication. And importantly, we say that the statutory scheme provides a comprehensive code for the conduct of a public inquiry, including, where necessary, restricted or closed hearings. And the question whether a particular power exists must be looked at with all of those provisions in mind, not just reading powers of isolation. And one key observation we would make is that in the submissions you've received so far, urging you to find that there's power, there's a very limited focus on the words of Section 17, almost in isolation, without looking at what else you see in the Act in terms of what that tells you about Parliament's intention in this very specific inquisitorial context. And we submit that neither the Act nor the rules make any provision, either expressly or by necessary implication, for the appointment of special advocates. On the contrary, what the Act and the rules do is provide you for a comprehensive regime for the withholding of closed material as necessary, for the holding of hearings in the absence of the public or in the absence of particular court participants, where there may be harm or damage which necessitates the withholding of that material. And that regime is principally to be found in sections 19 and 20 of the Act. And it's also important, we say, to recognise Rule 12 of the inquiry rules, which I don't think we have looked at in these 2 days so far. Rule 12 of the rules, I'll let you bring it up.
Yes.
What Rule 12 does is it tells you which individuals can have access to the potentially restricted material. Even persons who would not otherwise be permitted to see it can have access to that material for the purposes of determining whether a restriction order or restriction notice should be made. So Parliament is giving you tools, but also direction as to how you are to make restriction orders or restriction notices, who is to be there and present and making submissions. And it's distinguishing between potentially restricted evidence and restricted material. And we say that's a complete code. It provides you with the procedural tools necessary to determine whether to, and if so, how to conduct closed hearings. And that's also, we say, important to link back to section 17(1) of the Act, which begins with the words, subject to any provisions of this Act or of rules under section 41. What that's telling you is that you've got to conduct this inquiry subject to the very specific provisions that Parliament has designed for you. And then you've got these broader powers in section 17, but that's a clear marker in section 17(1 that where it's given you specific powers, that's where Parliament's chosen to strike the balance. That's where Parliament has decided, if necessary, fairness in certain contexts needs to be determined. And if Parliament had intended to include within that detailed scheme a power to appoint special advocates, we say it would have said so expressly, and the fact that it has not, we say, is a powerful indicator that there is no such power. And we draw upon some other key aspects of the statutory regime in making those submissions. The first point to make is the role of counsel to the inquiry. That role of counsel to the inquiry is defined in the Act, and that includes the ability to pay counsel to the inquiry, to provide remuneration. That's in section 39 of the Act. And also immunity from suit is addressed in section 37 of the Act. So where there are particular legal officers who are to have a role in an inquiry, the Inquiries Act descends to telling you that you can pay them, and it descends to telling you that they have immunity from suit. And if you look at those sections, we don't need to pull them up now, sections 37 and 39, they're very specific about the roles of different individuals, different legal officers within an inquiry, including counsel to the inquiry. And we say that the power to appoint special advocates has to be looked at in the absence of any corresponding provisions which address immunity from suit, address remuneration in the same way. There's just nothing. And we say that's particularly odd in circumstances where, as you've already observed today, the special advocate role is a very unique and special one. They typically own no duties to those that they represent in the closed session, and they have no lawyer-client relationship in the way typically understood between legal professionals and their clients. And that peculiarity calls out for being addressed and explained. And as you've seen in other regimes where the special advocate role is identified, those matters are addressed. There's also no provision for special advocates to suggest Rule 10 questions or apply themselves to question witnesses under Rule 10 of the inquiry rules. And we say this is another key indicator that special advocates are simply not part of Parliament's intention in this comprehensive regime. It is only recognised legal representatives who are able to apply to ask questions of witnesses, and a special advocate cannot be appointed to act as a recognised legal representative in the manner anticipated in Rule 6 of the rules. So accordingly, there is no provision in Rule 10 or any other provision that would permit a special advocate to ask questions or to apply to ask questions. That would have to be somehow worked out by the inquiry chair. We're not saying you couldn't ever work that out if in due course you decided there was a power and there was a discretion. But the absence of anything in the rules along the lines of Rule 10, which is a pretty specific set of rules as to how that questioning is to happen, and that's really because it points to the centrality of the role of yourself as chair and of counsel to the inquiry in leading the investigation. And that takes you back to the fact this is an inquisitorial, not an adversarial process.
In some of the various other statutory schemes which provide for the appointment of a special advocate, there's a very obvious and distinct distinction made as to what the special advocate can do.
Yeah.
So in some cases, for example, he or she can ask questions.
Yeah.
In other cases, they have to ask permission. Some cases they can lead evidence. Some cases they can't.
Yeah.
So, and all of that seems to be in order to tailor the function of the special advocate to the needs of that particular set of proceedings.
Precisely. Absolutely. And as you've observed, set of adversarial proceedings, because that's where we commonly see special advocates used. And that's where it cries out often for that kind of mitigating balance to be provided in closed, where you've got some kind of adversarial process or some kind of criminal or quasi-criminal process with allegations being made against an individual.
I mean, I've no doubt we could, between us all, devise a protocol for the working of a special advocate if that's where we ended up. But the point is that it's another interesting aspect of the structure of the 2005 Act that there is no such guidance.
No. Or any guidance as to how the special advocate role fits with the counsel to the inquiry role, how that relationship works. And as you've seen, as I say, in Rule 10, there's a very careful procedure for the asking of questions or permission to ask questions, which keeps control in the chair and the inquiry team. And that brings me on to my second point, which is about the purpose and the context of the Act. It's obviously well established that the purpose and context provide the basic frame of orientation for the use of the language enjoyed within it. We've cited a number of cases. There are many that can be cited to support that proposition. They're cited at paragraph 9 of our written argument. And so we have to consider the language that Parliament has chosen within the particular context which arises. And we focus on two particular features of the statutory context, which we say are particularly relevant to whether the chair has a power. First, we say it's clear from the context, the background to the Act, and the words of the Act and the rules themselves, that controlling the cost of statutory inquiries was a key priority for Parliament. And one need look no further than Section 17(3) of the 2005 Act and the duty on the chair to conduct the inquiry with regard also to the need to avoid unnecessary cost. You also have Section 39, which enables the minister to limit the scope of their cost liability if the inquiry departs from the terms of reference. And one only needs to remember the background to this inquiry. There was Bloody Sunday with the costs that arose there. It's in the consultation reports that costs at times had varied, but sometimes were spiralling out of control. And we say it's no accident that there is a significant focus in the 2006 rules on controlling the costs and expenditure. Some 16 of the 34 rules in those 2006 rules are devoted to the question of costs. And therefore, it's quite clear that that was an important consideration in the desire to update inquiries legislation. And one asks again, would Parliament have granted the chair an implied power to appoint special advocates without making any provision whatsoever to address the cost consequences of doing so? Such cost consequences consequences potentially being extremely significant in an inquiry with any measure of restricted hearings. And then secondly, and perhaps more fundamentally, we say the statutory context is an inquisitorial regime. And far from being irrelevant, as some have submitted today, we say that is perhaps the most relevant factor in terms of interpreting the Act. It's a different approach completely to that taken in the context of inter partes litigation, where the need for special advocates has usually been identified. A public inquiry does not involve parties pursuing competing pleaded cases or agendas, seeking to pull the investigation in different directions. And really important is Section 2.1 of the 2005 Act, which expressly prohibits the determination of civil or criminal liability by a public inquiry. And that's really important in terms of the context here. It's important in terms of what fairness requires, because you're never going to be in a position of actually determining what someone's civil liabilities are, or indeed criminal ones. These public inquiries are set up to look at matters of public importance, to look to the past, but then look to the future and make recommendations. That is a completely different beast from adversarial litigation. It involves an independent and objective investigation by yourself, assisted by your counsel to the inquiry if appointed. And the role of yourself in the inquiry, the role of your counsel, all the disclosure provisions within the Act and the rules, the Rule 10 process, are all consistent with that inquisitorial focus and inconsistent with anything approaching inter partes litigation. And we say it reflects the fact that there is no requirement for partial representation in an inquiry of this nature. All of those that are in this room, all of us, are here to assist you in your investigation. And we say that having special advocates to represent particular interests in the closed proceedings within that process is antithetical to that inquisitorial process, and antithetical to you having control over the investigation with those that you have appointed to lead that investigation. And that's baked into the whole scheme of the Act and the rules. So we say that context also adds force to the points that we make on the language of the Act. And then thirdly, we say that parliamentary intention, as evident from later statutes, reinforces those points. I don't say I need this third strand to my argument, but it certainly does confirm the points that I'm making. Parliament has made a number of changes to national security legislation to address what material can be seen by inquiry panels and counsel to the inquiry and by other inquiry personnel. The first change came about in the Inquiries Act itself, 2005, when the prohibition in Section 17 of RIPA 2000 was amended by paragraph 21 of Schedule 2 to the 2005 Act, providing an exception for material that might reveal the existence of a warrant to be disclosed to a panel of an inquiry where the panel ordered disclosure to itself. So that's where Parliament chose to start. That position was changed in February 2009 by Section 74(1) of the Counter-Terrorism Act 2008, where such disclosure was also then permitted to be made to counsel to the inquiry as well as the panel. Then we've looked at Section 56 in detail and Schedule 3 of the 2016 Act. And there we have the prohibition on disclosure emanating from interception, but subject to certain very clear defined exceptions, which included a panel of an inquiry or a person appointed as a legal advisor to such an inquiry. And that was expressly stated to include the inquiry solicitor as well as counsel to the inquiry at that point. So Parliament is looking very carefully at the personnel involved in an inquiry and is deciding whether this species of closed material can be disclosed to them. And we can be, we would say, very confident that there was no exception for special advocates in the 2005 Act inquiry context. Because, as your counsel to the inquiry has already helpfully pointed out, the Schedule 3 to the 2016 Act does refer expressly to special advocates in those terms when dealing with other types of proceedings, including civil proceedings where there's a closed material procedure under the Justice and Security Act 2013, including TPIM proceedings, terrorism prevention investigation measure proceedings, where the term special advocate has been used in Schedule 3. So it would have been very easy for Parliament to have used the term special advocate under paragraphs 22, 23 if they had wanted to make an exception for them, and they haven't. And we say that that confirms that it is Parliament's intention not to have special advocates in this very different type of legal process. We also say it's obvious that the phrase that Mr. Southey alighted upon, paragraph 23(2)(e) in Schedule 3, talks about a person performing functions necessary for the proper functioning of proceedings. We say again, it's clear that's not special advocates. Parliament would have used the term special advocates as it has done elsewhere in Schedule 3. And we say that's obviously meant to refer to all the ancillary personnel that might be necessary when restrictive proceedings are taking place. So we say that Parliament's had 4 opportunities now to indicate that special advocates could have such material disclosed to them in inquiry proceedings, but has not done so. And we say that strongly suggests that there is no power to appoint special advocates. And we ask, had Parliament thought that the inquiry had the power to appoint special advocates, why would it create a situation in which the panel, the chair, counsel to the inquiry, and the solicitor to the inquiry could all be provided with a certain category of closed material, but not special advocates? We say it just makes no sense. And that you have to try and interpret this regime coherently, and there is a coherent explanation, and it's that you don't have the power. That's our submission.
What you've been explaining to me just over the last few minutes is how we might identify Parliament's intention by looking to subsequent legislation.
Yeah.
I can also look elsewhere, perhaps, to try and identify Parliament's intention, can't I? Mr. Henry helpfully pointed me in the direction of the speech by Lord Sales in his written submissions, which in turn took me on to the decision of O against the Secretary of State for the Home Department, Lord Hodge giving the decision of the Supreme Court. And he was talking there about the importance of understanding Parliament's intention and the ways in which that might be identified. And at paragraph 30, he talked about how external aids to interpretation are available, although playing a secondary role.
Yeah.
And what Lord Hodge set out was things like explanatory notes, and they've been touched on already, yeah. and they talk of a comprehensive scheme.
Yeah.
Other sources, as identified by Lord Hodge, were Law Commission reports, reports of Royal Commissions, advisory committees, government white papers. All of these may disclose the background to a statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation.
Yes.
And the context disclosed by such materials, Lord Hodge said, is relevant to assist the court to ascertain the meaning of the statute, whether or not there's ambiguity or uncertainty. So we have, for example, the effective inquiries consultation paper. Yes. There wasn't a white paper, but no. the consultation paper took its place. And I wondered also about whether or not it might be appropriate and of some value to think about what was said in Parliament. Now, I recognise, of course, that one would have to be very careful about that. And I think, generally speaking, one would look to statements as to the purpose of a bill that were made by the Minister.
Yes, in accordance with the rules in Pepper and Hart.
So
yes.
you wouldn't be looking to what the general parliamentary discussion was.
No.
But it might well be possible to gain something from what was said by the Minister who introduced the bill. When the inquiries bill came before the Commons for its second reading, it started out in the Lords, of course, but it came to the Commons for its second reading. It was introduced by the Under-Secretary of State for Constitutional Affairs. And as far as I can see, he explained the purpose of the bill as having 3 strands to it. He said the bill was designed to reform the arrangements for conducting inquiries into events of serious public concern. Secondly, he said the bill created a comprehensive framework for inquiries set up by ministers. And thirdly, he said the bill would put on a proper, more comprehensive footing our ability to conduct an effective public inquiry in circumstances where national security issues may well arise.
Yeah.
So those are the 3 strands of the bill.
Yeah.
So it's not as, and of course section 19, although it wasn't numbered in that way, was repeated eventually in the Act as passed. Sorry, section 19 in the Act was numbered differently from the bill, but
yeah, it was.
The words were the same. So what we see is that the 2005 Bill and Act had in mind a number of fairly straightforward purposes, but one of which was to put on a proper footing the ability to deal with national security issues.
Yes.
Whereas it hadn't been able to do that properly in the past.
Yes.
So it's not as if Section 19 was some sort of consequential or minor addition. It was a fundamental plank of the bill.
I agree. Parliament faced that squarely and looked at it squarely and designed procedures meant to address it. And they were successful in doing so, because the proof of that is the number of inquiries that have happened subsequently with a substantial national security element that have found the tools that are given in the Act and the rules perfectly adequate. They're Article 2 compliant, I'll come to that. And so when Parliament intended to try and create that comprehensive new statutory framework, it did it. And it did it after a lot of consultation and a deep understanding for many years of how inquiries, with all different as we know, there were inquiries set up under lots of different statutory powers, including ones in this jurisdiction. So it gathered all that experience together, and it put in place a scheme that has, we say, stood the test of time. And Parliament has chosen not to tinker with that either.
It's also possibly relevant just to bear in mind the timing of all of this, because the bill was going through Parliament in the early part of 2005, at a time when there were already in place a number of other statutory schemes which cater for the appointment of special advocates.
Yeah.
In a raft of different circumstances, employment, planning, immigration,
yeah.
all of these different areas. And one curiosity struck me, which was that, first of all, there were closed proceedings available in some Planning Act proceedings, which came as something of a surprise to me. But there were closed proceedings available in the Town and Country Planning Act of 1990, the Planning Listed Buildings and Conservation Areas Act of 1990, and the Planning Hazardous Substances Act of 1990. So from 1990 onwards, in each of these different spheres to do with planning, there were proceedings anticipated in which there could be closed hearings.
Yeah.
But there was no provision for special advocates until Section 80 of the Planning and Compulsory Purchase Act of 2004, which amended each of those pieces of legislation by adding provisions allowing the Attorney General to appoint a person to represent the interests of any person prevented from attending the hearing or inspecting the evidence of the inquiry. So, for all of the years that passed between 1990 and 2004, closed hearings could be held under those proceedings. But for some reason, when the 2004 Act was going through, it was realised, well, we'll need to make sure we can have special advocates there. And that, in terms of timing, just raises the question of, well, could Parliament possibly have been ignorant of the need for special advocates in relation to Inquiries Act when it was doing the bill a few months later?
Yeah. And Parliament would be taken, as a matter of statutory interpretation, to be aware of that, either from the planning context or the immigration context. I mean, by that point, you'd had the SIAC Act for some time, from 1997.
And it's the timing that struck me as...
Yes, it feels very pertinent, yes.
Just all around the same sort of time. They're aware of the need for special advocates in some circumstances, and yet, if aware of them, of the need for them in Inquiries Act proceedings, they leave it unsaid.
Yes, exactly. And we say there's an obvious reason for that. It's because there's a complete code, a complete framework that enables inquiries to do what they're intended to do in an inquisitorial way. And as I say, special advocates are, on one view, anathema to that, because they bring about an adversarial nature to the proceedings, which we're meant to try and avoid. That's not the way inquiries are meant to work. So the high point of Mr. Southey's case, I would submit, is the Roberts and the Parole Board decision. It's already been discussed at length. I would just make a number of key points about that. Obviously, I have to accept that that's an example in a different context of the court deciding that it was appropriate in that case to imply a power to appoint a special advocate where you'd got a statutory tribunal rather than a court. Because a lot of the cases that involve courts, it's easy to see how, for example, a high court exercising its inherent jurisdiction.
Yes, it's very different.
It's very different. So Roberts is obviously a case to look at, and as you pointed out, it's a case that other chairs in other public inquiries thought was potentially relevant to this question. But I'd make a number of discrete points. First, the context. The context in Roberts could not be more anxious from both sides of the equation. From a public safety point of view, it was obviously important that the parole board had all relevant material relating to risk of this particular prisoner. He'd been convicted of murdering 3 policemen, and so the parole board had to be able to see all the relevant information that was going to go to the risk he would pose if released on licence. From the other side of the equation, it involved liberty of the subject. One of the most anxious contexts, should this man be released from prison after a long spell in incarceration. So on both sides, the stakes were high. And as we know, context is everything when it comes to fairness. If you need any more support for that, in Roberts at paragraph 40, Lord Wolfe makes those very points about fairness not being a single unwavering standard. It varies according to the nature of the decision, for example, to be made. And in Roberts, there were some express powers, which, as you noted yesterday, were quite important when it came to the majority decision. Those powers included the fact that there was power to hold a closed process, to hold material restricted from the prisoner, but also the power to take steps incidental or conducive to the discharge of its functions. And as you noted, that was seized upon both by Lord Roger and Lord Carswell as a key aspect of its express powers, which enabled them to imply that there was also the ability to have this mitigating counterbalance in the appointment of a special advocate. So the express powers of the tribunal were different and were germane to the decision of the majority. It's also worth bearing in mind the two dissenters. There was Lord Bingham and Lord Steyn dissenting, not insignificant voices, but that's another point. And I would submit that that was a case where there was an obvious gap in that they could have a closed process, but what was at stake for the individual was so significant that they needed to mitigate that, and the obvious mitigation was a special advocate.
I wondered if it's even more than that, because if you just say that the board is allowed to look at the material and the prisoner isn't allowed to participate, then it's patently not compatible with Article 5.
No.
So it fails.
Yeah.
And by that stage, the board's procedures had been amended so as to make them compatible with Article 5.
Yeah.
So there was no difference between the concept of fairness in terms of the board's domestic procedures and what was required by Article 5.
Yes.
So fairness in terms of its domestic procedures required an adversarial hearing.
Absolutely.
Just as Article 5 did. So it just couldn't work at all as a matter of law without a special advocate.
Yeah, absolutely. And so one can see why the Supreme Court was compelled to do what it did. Sorry, the House of Lords, I think. And so when one appreciates all that by way of context, you can see that the force of any read across to this context is very, very limited.
Well, I have to look at fairness, of course, but it would be difficult, and I don't think anyone said this, it would be difficult to suggest that in inquiry procedure, fairness requires a special advocate as a matter of law.
Yes.
We see from other inquiries that it doesn't.
No.
So that's the distinct difference between Roberts and an inquiry procedure.
Yes, I agree. So that's what we say about Roberts and about whether or not there is this implicit power to imply here the appointment of a special advocate. I'm going to deal very briefly with the question of whether Articles 2 or 3 of the ECHR have any bearing on the issues that you're considering. In our submission, the case law is clear that whether it's Article 2 or 3, the investigative obligation does not require the public or core participants to have full access to all parts of the inquiry proceedings and evidence, and that Strasbourg has on a number of occasions approved the use of closed proceedings where necessary. Cases such as Armin, Ramshahai, JL and the Secretary of State for Justice all make that clear. And we're left back on the test of the next of kin must be involved to the extent necessary to safeguard their legitimate interests. And what we say is there's certainly no case that anyone can point to that says in our inquisitorial context a special advocate must be appointed in order to comply with Article 2. There's nothing approaching that at all. They have to be involved to the extent necessary to safeguard their interests. And when one looks at it from that prism, they are heavily involved in any public inquiry, the victims, the families. They have a right to legal representation. They'll be able to make applications for core participant status. They will have the ability to work with counsel to the inquiry, to suggest questions, or even to apply to the chair to ask questions themselves. And the way the Section 19 process works is that it's only that material that they can't see and will never see that has to stay enclosed. And by definition, that can't be material that they can give instructions on because they're not aware of what it says. And any concerns that they've got, any suspicions they have, any lines of inquiry they want pursued, can all be pursued by counsel to the inquiry. So
what do you say to Mr. Southey's point, though, that it's part of their interest to be able to ensure that nothing happens in the course of a closed hearing which constitutes an error of law?
Yes. I say a number of things about that. First of all, this is an inquisitorial process. What you are doing is investigating, essentially investigating facts in closed. You are not reaching any determination of civil or criminal liability. That point is really important. And by definition, Section 19 will limit the material that will be covered by that closed process. And so you're not reaching any legal determinations on the closed material. You're not like the Investigatory Powers Tribunal determining whether someone's right to privacy has been breached under Article 8. You're not allowed to make those findings. You're primarily a factual investigator, and then you're going to be assimilating the facts and reporting on those.
I think Mr. Southey saw a legal determination as being something a bit broader than that. He also contemplated the fact that maybe if a special advocate wanted a particular line of inquiry to be advanced and the chair decided not to do so, that could conceivably be challenged.
What we say next is that Parliament struck the balance. Parliament has decided what fairness primarily requires in this context, and it requires you as an independent chair of this inquiry. It requires counsel to the inquiry to be appointed who have the experience and the expertise to deal with the issues the inquiry is investigating. And Parliament has set up that process. And yes, I accept that by definition that might mean that something happens in closed that the open advocates aren't aware of and can't challenge. But Parliament has decided that the safeguards that it's put in place, your independence, the role of counsel to the inquiry, mean that its fairness is mitigated to the extent it needs to be mitigated, given what you're determining. And you're not determining civil or criminal liability.
Mr. Southey was arguing for what he called an independent mechanism. I did wonder at the time what I was supposed to be if there needed to be yet another independent mechanism.
Well, absolutely. And you can't put checks on all the inquiry processes. And the inquiry might take a false step. They might take that false step in open, and nobody might notice that. But that's the scheme that Parliament has decided is appropriate for determining these issues, given that ultimately it can't pronounce on people's liabilities. It's there in order to investigate matters of public importance, to find the facts, but then to make recommendations for future change. And so we say that, yes, you don't have someone sitting on your shoulder in closed, checking all your homework, but frankly, when one looks at what was intended in the Inquiries Act to create a comprehensive regime, but also one that was proportionate in terms of cost, that is simply not necessary.
And you say that's the same answer to the point about the need for public reassurance?
It is, and that's what it boils down to. The words that come to mind in the last 2 days are it's about reassurance, confidence, robustness. One can understand on a human level why those points are being made, but ultimately you have to have faith in your own appointment, your independence, and the skill, and I'll come on to it, of your counsel to your inquiry. And that's clearly where Parliament decided the burden should lie in terms of making decisions about the scope of these investigations, what lines of inquiry to pursue, what was relevant, what was not relevant. Inquiries have to make those decisions every day. And someone might second guess them. The other point I would make is, just if we look at the case law, it is very, very rare for the courts ever to sit in judgment on judgment calls that have been made by an inquiry chair or their team. And there's a lot of case law to the effect that an inquiry has to go very wrong before the court, the administrative court, would decide that there was an error of law. And they give a huge amount of discretion, of latitude to inquiry chairs and to their counsel to conduct matters both procedurally and substantively in the way that you consider is most effective. And so again, I think that's relevant to, well, do you need someone sitting on your shoulder checking your homework enclosed, given how hard it is to challenge decisions that are made by public inquiries? And that's for good reason. And it's, again, for the same reason that deference, that latitude that courts give, it is enshrined in the Act. And it reinforces my point about the way in which this is a very unique statutory scheme. We say, in terms of previous rulings by inquiry chairs, and with no disrespect to those chairs and those that were making legal submissions, the arguments that you have heard in writing and over the last 2 days go way beyond anything that we see in those decisions. I'm afraid they do look quite superficial now, given the depth of argument that you've had and the number of points, including the points about the 2016 Act and the limitations of special advocates that don't appear to have been taken into account in those decisions. So whilst, of course, you should have regard to them, we say they're of very limited persuasive effect. So if I can now move on to deal with my 8 points, and I'll do this as efficiently as I can, as to why you should not exercise your discretion. And I'll try not to repeat myself, because some of the points that are talked about in terms of discretion, in fact, I would say go to, is there a power at all in the first place? But first and most importantly, this is an inquisitorial process. We've laboured that point. I've laboured that already. Secondly, you and your team of counsel to the inquiry will test the evidence given in the closed hearing with the same diligence, care and objectivity that you bring to the open hearings. You have an experienced and capable legal team behind you, in front of you, expert in dealing with closed as well as open material. Your lead counsel to the inquiry and one of the silks assisting him, and your solicitor to the inquiry, all acted in the Manchester Arena bombing inquiry, which heard closed evidence in restricted hearings. Amongst many others. Pardon?
Amongst many others.
Amongst many others. I'm sure that's right. Your solicitor to the inquiry also has experience of the Litvinenko inquiry and various inquests, including the 7/7 London bombings. And that's relevant to whether or not you need to exercise your discretion to have another legal officer inputting into the closed sessions. Thirdly, all of the special advocate regimes, and it's not in contention here, contain express provision to the effect that special advocates cannot communicate to the specially represented persons after they've had sight of the sensitive material. And so that being so, the instructions given by core participants could not go beyond a general instruction to test the evidence carefully in order to establish whether there may have been missed opportunities to prevent the bombing, and to pursue certain lines of questioning emerging from the open evidence. And that's precisely the task that can be undertaken by counsel to the inquiry, informed by the Rule 10 applications that may be made in the open hearings. The open advocates can prepare a detailed list of questions that they want put in open and in closed. That can be provided to counsel to the inquiry, and obviously counsel to the inquiry will take those into account when they approach their preparation for the closed hearings. And indeed, counsel to the inquiry is going to be in an arguably better position than any special advocates here, because they can continue to communicate with the core participants for the families, despite having seen the closed material. Fourthly, there will be a duplication of function between counsel to the inquiry and any team of special advocates. We say that's inevitable. And given your duty under Section 17(3) to avoid unnecessary cost, we say that you would have to identify something very particular, very special, that meant that special advocates could do something which your team of inquiry counsel could not. Special advocates are a scarce and precious resource. They are needed across lots of different jurisdictions in very anxious contexts. And we would say there's no justification for the inquiry or anyone else incurring that expense in circumstances with the duplication with the role of counsel to the inquiry is so obvious. Fifthly, as we've already seen, there are some family groups that would one family group would like their own special advocate, separate from the special advocate that was appointed in the judicial review proceedings. So that gives rise to the prospect of multiple special advocates. And even if you try and keep that confined, you certainly can't achieve it with the appointment of one or perhaps even two people. It's likely to have to be more than that. Sixthly, delay. And we say delay is really important. And obviously you've heard Mr. Mansfield's submissions on delay. But promptness is a key consideration in an Article 2 investigation.
I think you need to stop there. That's going to go down badly, given the amount of time that's passed before we get to an inquiry.
I was just about to make that very point. I was about to say I'm on slightly shaky ground here when I talk about promptness, but nevertheless, that doesn't mean that you don't sit here now and say to yourself, is this a step that is or is not going to cause delay? And clearly you've got to factor any delay into any decision that you make. And we say it's obvious that if special advocates are appointed, they will need time to prepare, they'll need time to read whatever open material they feel they need to read before going into close, they'll need time to take instructions, and then they'll need time to input into the closed process. It will increase the time that the closed hearings will take, and all of that will mount up in terms of the point at which you can get to a report writing stage. Seventhly, any such appointment, we say, is likely to make the hearings very complicated. I make this very special point, particularly where you've got some closed material that special advocates couldn't see and some that they could see. That raises the spectre of having two types of closed process. And what we say about that is that actually makes things very complicated, not just for the legal teams, but actually for the witnesses who are giving their evidence, to be told, well, when you're answering these questions, you can only refer to this corpus of material. When you're answering these questions, you can now refer to this wider corpus of material. And actually what we say what you should focus on is what's going to get you the best evidence and what's going to put those witnesses in the best position to give you the best evidence. And having that kind of confusion on top of the length of time that's passed since these events, we say could really cause a lot of complexity, hypothetically, assuming that we have that type of material. And for the avoidance of doubt, we neither confirm nor deny, as is put in our written submissions, whether there is such material in our submissions. And as I think, as you said earlier, you're testing this out on the hypothetical basis that if there was such material, how would things work? Finally, while it's accepted that each case is different and requires individual consideration, we say it's significant that a proportion of those public inquiries which have included closed hearings have been concerned with fatalities and have had bereaved families as core participants. So what we say is there's no difference, we would say, between, for example, the families in the Manchester Arena bombing situation and the families here. And no previous inquiry has identified the need to appoint a special advocate. As to the test that should be applied, we submit that nothing less than the high bar identified by Lord Bingham in the Crown and H should apply. Such an appointment will always be exceptional, never automatic, a course of last and never first resort. And we note that that test was reiterated by the Court of Appeal in the Concordia case as recently as 2018. Even if the test is better expressed as one of necessity, which some co-participants have submitted, we submit that it also fails to meet that similarly high bar. And we would say that nothing that has been submitted to you would satisfy that necessity test. As to the position of the former Chief Constable, we submit that it's premature to start speculating in any detail precisely who will be present at which hearings and which witnesses might see any closed material, those questions will have to await a lot of stages that will need to be gone through before that process. So we don't think that that is a material consideration at this stage. As to practicalities of the appointment, those practicalities would need to be worked out depending on what the identified need for such an appointment was, as articulated in the chairman's request. It is our position that it would have to be a request to the Advocate General of Northern Ireland, who is responsible for making those appointments. You will have to identify whether you say there's a power, and if so, what you're doing in terms of your discretion. If you do request the appointment, you'll give reasons for that. But then the Advocate General will have to take a separate decision as to whether or not to appoint them. He will obviously have to take into account the reasons that you give, but it will be a separate decision by him as to whether or not he is prepared to make that appointment. And then cost, we also say it's premature at this stage to tie yourself down in terms of cost. That will have to be worked out, again, depending on the identified need, how many special advocates. There are various options that have been posited in the submissions. We submitted in our main submissions that there certainly wasn't an obvious case where simply the provider of the material would have to pay the costs. There are potentially other options for that. But we say those are practicalities that can be worked out once your in-principle decisions have been taken.
But wherever the cost burden falls, it's bound to be public purse.
Yes. Mr. Chairman, is there anything else I can assist you with? Otherwise, those are our submissions.
Thank you.
So could we have what will be, I expect, a final break, following which we'll hear from Mr. Henry on behalf of the Police Service of Northern Ireland.
Mr Henry, good afternoon.
Good afternoon, sir.
Yes.
So you will have seen a very lengthy written submissions put in on behalf of the PSNI. It's not my intention to read that out or even to summarise it. I'm conscious that a lot of the ground that is covered within that note has also been covered over the course of the last day and a half or so. I'm happy to adopt that submission, that written submission, as the PSNI's position. I'm also equally happy to address any specific questions that might arise from that or from other points which have arisen during the exchanges between yourself and other counsel. But otherwise, I would have nothing in particular to add. I'd be covering old ground.
Well, as I mentioned earlier, I was grateful to you for your suggestion that I look at Lord Sales's speech. I found it interesting, and also for the pointer in that speech to the case of O. And I've considered the rest of your submissions with care, and I rather think everything has been canvassed one way or the other during the course of the discussion yesterday and today. So for my own part, I don't have anything in particular I would like to raise. If you're content to simply adopt the submissions, I'm happy with that also.
Thank you very much, sir. I'm content with that.
Thank you. Yes, Mr. Greene.
Well, so we have then managed to conclude this important hearing in the course of 2 days. And it remains for us finally to thank all co-participants for the care that they have taken over their written submissions and oral submissions and for the clarity of them. And we, for our part, consider that you are now well equipped to determine the important issues that this hearing has presented for you. We do anticipate that there will be a further procedural hearing at some stage between now and the commencement of the Chapter 3 or evidence hearings. And so we will communicate the date of that hearing and its length to all core participants at some point in the future.
Yes, thank you, Mr. Greene. In terms of the hearings yesterday and today, I'm very grateful to all of the Council for the submissions which they've presented. The issue which has been raised is both important and interesting. It's necessary that I take care to reflect on all of those submissions, and I will produce a written decision in due course.
Thank you, sir.